Matter is ready for hearing. Okay.
Lordships, any specific date?
He'll give a date. He'll give a date after this.
Early date,
Okay.
it's an age-old matter, your Lordships. 60 years old.
27, 88 to 94, 95.
Item 94, my lord, the LCR has not been received. The packet posted.
94. LCR hasn't come. LCR called for a TCR. TCR and release the matter out. Yes.
My lord, I have filed several memo. This is the 6th memo. This is the matter of the criminal miscase 2022 matter. Author matter will be listed, matter can not be listed. Kindly fix it.
What is this matter is about?
That the petitioner is then hospitalized position and police is apprehending to arrest him.
What are you asking?
This is the matter of 22 matter.
I understand what is the prayer in the
Prayer is that the petitioner is in leave in the after religion interim bail. They are admission in the hospital, my lord. And the police warrant.
I'm asking, what are you asking in the petition? Is it a 482 petition? Quashing? What are you asking?
Quashing.
That's you.
Yes, ma'am.
In hospital.
No, I am not understanding.
Okay. It's all right. You give it with memo.
What a fixed date.
May I submit?
Yes, sir.
Item 8 in your lordship's list.
18. Yes.
08.
08.
That a mention was made virtually by the opposite party's counsel and it has been adjourned. I am told.
No, 8.
Yes.
The mediation is fixed, I think.
My submission is this, my lord.
Yes.
The petitioners here are relations of the husband, my lords.
Yes.
Married sisters-in-law and married and uncle residing separately. Your lordship permitted that the mediation proceeding should be done virtually, to appear personally. This is nothing else.
Blood.
Yes, Mr. Mishra, see,
It is absolutely harassment, my
the
lord.
idea is to work for a
Yes.
mediation.
Yes, I do.
Doesn't
And
that
Milord, the other day, Mr. Panda was there, Junior Panda was there. Initially, they raised that point that we have nothing to do with this case. But however, they again told the arbitrator, the mediator, yes, we will take instruction. Rahul and the other, they are the main.
Shall I make it clear? Now, make it clear. If
Your
a party
lordship may be virtual, your lordship may.
a party can't appear, let them appear to
yes.
VC. What is it?
Lord, I have no.
If in the court one can appear in the VC, why not in the mediation?
Yes, my lord. But
I
since
don't.
it will be more effective, so
I know, but see, if it is necessary, let the mediator take the call.
Yes, well,
Let
yes,
the mediator
mediator.
take the call.
Yes, lordship. Your lordship. may-
And in that environment only you can ask for mediation. Now, if you
No, I am not. That I am not.
Yes.
Lordship may modify the arbitration.
Mr. Panda, you are appealing for petitioner. Mr. Panda, let counsel for the petitioner submits that the matter, although is referred to mediation and the mediation process is going on, and next date before mediation center is fixed on 24th of February. But the petitioner, you are staying abroad.
No, I am staying at Hyderabad and
The
at
petitioner, the
Calcutta.
petitioners may be permitted to participate in the mediation process through video conferencing mode. It is open for the mediator to consider the prayer made by Mr. Panda and allow his clients to appear through video conferencing mode.
Your lordship may also observe. If possible, they may come. If they possible.
No. Why should they?
If
Why should
if
they?
it is
No, my lord, my sub, Mr. Mishra has got a hidden agenda behind it. He wants his party
You are
to
well
remain at
protected.
Sambhalpur or wherever, but he wants my clients to come to Qatar. This is unfair.
I think both of you should be, don't
This is
hinder the
unfair, and he
mediation process,
insisted
please.
upon this after the mediation proceedings were over on the last.
These are small issue, mediation.
issues.
He
Supreme
has
Court-
a habit of making
Mr.
things.
Mishra, you have been appearing in Supreme Court through mediation. Sorry, BC.
Yes, my lord.
Shall we prevent you?
Also, today item number 5 is there in court. Sorry.
Let them appear.
My senior
Anything
Panda
happens,
sir.
then we'll
Yes.
we'll sort it out.
Yes.
The interim
And
orders.
if my senior Mr. Panda will resign, it will be resolved. That is why, and if you will continue, both will be benefited by appearing so many dates.
No, for Mr.
idea is to-
Mishra,
idea
it
is
is
to
better
get
that it continues.
Idea is to get it,
Yes,
sorted out. That's the idea. Yes.
My senior brother will desire, it will be sorted out as soon as possible.
Yes.
With due apology, my lord,
Yes.
the present applicant has the custody near about 5 years. Out of 10 years conviction, it's a special assignment to my lord, my lord. In a
5
NDP,
years?
inside the custody. In a NDPS, my lord, 37 kg ganja on the accusation of carrying of 37 kg.
Antecedents? Oh,
No
this is
antecedent.
bail application.
In a criminal appeal, my lord. It's specially assigned to my lord.
Okay. List. Yes.
I want to mention my.
I pass an order 436 capital A. You are
No, it's a conviction.
okay.
Conviction.
Conviction matter.
Yes, 5 years.
I want to mention my lord. One item specific adjournment to 20th January 2025, my
We
lord.
give
Not
memo.
request.
See, yes. Let us proceed.
Okay.
Yes. 3. Yes. Item 3. What are you seeking, sir?
Taken
Yes.
1 week after, my lord.
No, but there is an opposition. He says that
It's
it is
seeking for
infectious.
Quashing of the proceeding below. It's a cheat fund scam. Already principal accused has been convicted in the civil offences. And he has also appeared before the special court. Now matter is framing of charge. And from 26/11, my lord, he has sought adjournment. He has not served copy on that day. Also had submitted. He should be directed. Your lordship has asked him to submit from November, my lord. He is not serving copy.
I will
my
serve.
lord.
No, no,
Copy.
you have filed it, argue it if there is an opposition. PMLA, the principal accused has already been convicted in the schedule offense. What are the grounds?
It's a cheat fund scam, my lord.
What are the grounds, you tell me?
I have
There
already
should be
served
some
the
ground.
Yes. I will argue on next. Urgent person.
Is there any ground, in fact, subsist?
Especially for myself.
Lawyer friend is asking your lordship to keep it some other day.
Okay, shall I put it day after tomorrow?
No, next week. Next week.
First week of this, huh? First week.
A copy be served in the meantime.
Yes.
to-
Please supply the copy.
Yes, I will serve.
But do you have a ground? That's very important. You have just seen.
Yes, I have some good ground.
Yes, good ground.
Yes.
Supply the copy, then all the ground will be demolished.
Respect of Pramod Kumar Pandit, there is no specific only mass, though there are 167 persons acquitted on the PML case on 84. So, in respect of myself, I have no.
We'll see. Okay, give
Next-
a copy.
next
Give a
one.
copy to him.
I will.
First week. of
My
yes.
name may be indicated.
Mr. Agarwal.
Along with Miss.
Unfortunately, I have.
Srivastava.
You must give you the.
Along with
Ah.
Un-
Miss Srivastava.
Madam, give. Now he has become senior. He can't appear without instructing
I'm
counsel.
not holding them.
Yes.
Unfortunately, I have served this. So,
Now you give it.
I will.
Give it to the instructing counsel.
5.
May I please your lordship?
Yes, sir.
Lordship, the petitioner praying to direction may be given to the trial court, may be expedited to trial, my lord. To disposal the trial in very
Well,
my
you
lord.
are accused.
Yes, my lord. The case is
21.
the case is under section 420 and which was lodged by the EOW Bhubaneswar, my lord.
You are
And
accused.
charge sheet has been submitted by the EOW on dated 31 January 2020.
It is an accused in FIR number so and so. And after investigation, charge sheet has been filed in the present case on 31/1/2022. What is the stage now? Nothing is happening.
My lordship, the evidence is now going on. Yes, my lord.
Counsel for the-
Yes, my lord.
Counsel for the petitioner submits that although the prosecution evidence, recording of prosecution evidence is going on. However, the trial is not proceeding at an expected pace. Hence, he seeks the court for a direction for speedy disposal of the trial. Since the prosecution evidence is already started, no such direction, in fact, is necessitated in the present petition. However, needless to say that the petitioner being an accused has a constitutional or statutory right of free, fair, and speedy trial. And the trial court is the trial court shall do well to see that the trial of the case is expedited. Yes. Yes. Next.
Number 6.
May I please answer? For question of the criminal proceeding of the receiver, compromise among the parties follow. The doctor has lost the FIR against his brother and married doctor, lost the FIR against his brother and the mother.
307 injury. Show me the injury.
Injury may not annexed to, let's say, Kyler glance and I thought of the injury. They are not granted by this honorable court. Let's see, it's placed 16th third paragraph, my lords. All the injuries sustained by the injured are simple in nature. All the injuries are.
What is the stage? What is the stage now? Trial.
Trial
Sure.
Okay.
Where have you said that trial has not been? 2016 FIR.
because the trial
And you got the bail in 2016.
the charge sheet when recently filed, it's
Give me the date of charge sheet.
I don't have to supply the next day.
You give then I need to know what is the stage.
I am for the informant.
Informant, where have you said that trial has not been started or anything? In the petition? In the petition, you have not said anything.
No, man, I'm not sure. I'm
Then-
not sure.
Where from I'll get that the 2016 FIR and you don't make an averment in the petition that the trial has not started. When the charge sheet is filed, that also you have not said.
I supply the next day.
Okay.
Yes,
Simply issue notice on advance notice so and so entered appearance. Yes.
Madam, I have filed affidavit
My
along with my.
File the affidavit. File it. And tell me the status.
Aye.
Yes.
Right, first week of March.
First week. Okay.
Will I produce the accused and the informant?
I don't know. You have settled. I should know that what is the stage. I'll.
Supply my order. My submission is my. That I am the informant. My lord. So that day I.
What is the stage of trial? You tell me.
Still not.
Not complete. Where have you said in the entire petition? Where have you said in your affidavit?
No, I am not.
When the charge sheet is filed? When the charge sheet is filed?
Charge sheet is in field submitted.
Everything.
Nothing is written, and you want quashing. And 2016 FIR.
Sorry, madam, I have not uploaded it. Sorry, madam, I have not uploaded it.
These are minimum things one should tell.
I should not.
And after quashing, pata chala ki bhai trial is the concluding stage.
No,
Then you will come and tell sorry.
Madam,
That's all.
It's not my habit to tell lie in the court. Madam.
But you should have written. I am not
I
telling you
should-
lie, but
I
you should
should-
written. These are very minimum things.
I should not. I
Yes.
should.
Yes. Next.
Item 7.
Yes.
CRLC,
Yes, sir.
I'm challenging the cognizance order passed by JMFC Chandigarh at annexure 1. In this case, the status quo order was in favor of the petitioners, and the complainant informant has intentionally violated the order of the trial court. As a result, this case has been registered against the present petitioners, and the petitioners are husband, wife, and their son.
Oh, yes.
And they belong to one family. Exactly. The informant is also the wife of the younger brother of the petition number 2. This is a family dispute out of a civil case which is pending.
Who is the informant here? You have not implemented the informant.
Right? This is a GR case. So
That's right. Informant has to be family dispute, and you have to implement the
Civil dispute.
informant also.
Civil
Family
dispute.
dispute, I could have done
yes,
something.
so this is arising out of civil dispute.
That's right, but
Yes.
you have to informant. Then
Yes,
only I can.
I
write-
will implement.
Then counsel for the petitioner seeks leave of this court to implement the informant
As
in
an
the present case as opposite party number 2. Let him do so within 2 days. If the issue notice to the newly implemented opposite party. Opposite party written also demanded memo parties to file.
I'll file the one IA. Date is ahead.
Now, what is the stage?
Trial has not commenced. Charge sheet is already been submitted. Milord. That is in fact
When the charge sheet is submitted, cognizance has been taken.
second. And charge time is
Okay, we will move application for trial court for example. Yes.
obliged.
But implead
Yes,
immediately.
in 2 days.
Hmm.
It's my verbal undertaking.
Yes.
It may be recorded.
Item 9.
Requisites also you have to file, huh? Immediately. Yes. Yes. Yes.
My lord, this is an application for passing the order of cognizance by annexure 1, my lord. I may draw the lordship's attention to the affair at page 16. Page 16,
1-6. Okay.
There no place of occurrence and no time of occurrence has been given.
That is
And
not
it
necessary.
Prima facie reveals that they have previous enmity, and accordingly another affair against the complainant is there. That is at annexure 4, my lord. The cognizance was taken on section 452, 323, 506 and all that. My lord, moreover, the petitioner, my lord, is a practicing lawyer of this court, my lord. Has been falsely implicated because of this monetary transaction.
Let us see the charge sheet. What are the allegations?
Charge sheet, my lord, is at annexure 1.
Yes. Come to page 26.
The case record is put up today as IO has submitted charge sheet on so and so on section 452, 323, 294, 506, 34 IPC. Cognizance was taken 452, 323, 294, 506, 34 IPC.
Yes. You
Affair-
had lended money to someone. He has paid.
That is
Part
the
of it.
allegation.
That is the allegation. That is the charge sheet. Yes.
Man.
And since the remaining part he didn't pay, you enter into the house, you and your wife,
Man,
and
the-
started abusing. These are the statements and all.
When I went to her house, no date, no place is mentioned. So, my lord, what I beg
those
to
things
say,
will be established by
no,
so could have discussed with IIC on telephone over the apprehension and the accused questions on this.
and admittedly, my lord, annexure 4, your lordship may kind of a plan.
Please show me the statements, 161 statements.
Uninitiated, I will bring it.
You will get the dates and all in that statement. Read those statements. There are specific allegations against you.
The informant, Mamata Malik statement.
ଆପଣ 161 statement ପଢିଛନ୍ତି ସବୁ witness ର?
ହଁ ମୁଁ ଦେଖିଛି specifically implicate କରୁନି ମୁଁ ଦେଇଦେବି.
You have to read that.
Okay.
There you will get the dates. Yes. Oh, simply read them. Yes, next.
Item 10.
Let counsel for the petition seeks an adjournment to place on record the statement of witnesses recorded under section 161 CRPC by the police during investigation. Yes. Next.
10.
Date may be.
Immediately. Yes, 10. Yes.
My lord, Mr. Amitabh Tripathi has been engaged to appear in this matter. So on its behalf, I'm praying for after lunch.
After
Lunch.
pass over.
Okay.
11.
My lord, the case fixed for defense, I applied to the court for issuance of summons to the defense witnesses, which was rejected by the learned trial court on the ground that the witnesses are private persons and some of them belong to my native village. That is no ground, my lord. The witnesses will not come. That is why I applied for issuance of summons. It's a very small
Where is
matter.
that? Where is that?
The impugned order.
Where is your application?
The impugned order will speak for itself.
Yes.
Application I have filed 8 to 11 is the impugned order. My lord can come to the page 10.
File to 311 CRPC to recall PW 4 and 15 for further cross examination.
No, lordship. Page 10, your lordship may kindly
So
come.
the said witnesses were examined on.
Order dated 13/12/2024.
13?
13/12/2024.
Page?
Page 10, my lord.
Today
The second para, on perusal of the list of
stating that
witnesses.
in that he wants to verify and unexhibited the documents. And charges them.
Not that, the next page, Lordship.
Okay.
On perusal of the
1312.
1312.
Okay.
Second para. On perusal of the list of witnesses given by the learned defense counsel, it is found that all the witnesses are private persons and some of the witnesses are native village of accused. Hence, it is the duty of the accused to bring the witnesses for his evidence. So the petition filed by the accused learned defense counsel to for his
Show me
witnesses.
the list of witnesses.
The list of witnesses are 9, my lord. 1 to 7 are private persons, 8 is my wife, 9 is myself.
So you,
1 to 7 I want to.
they are villagers.
They are, some of them are villagers, some of them are not.
Why can't you bring them?
They will not come, Lordship. Issuance of someone at
If
my
they
place.
don't, they will.
I will serve the
No,
summons.
they will not come. Then how do you think that they will support you?
Lordship,
You by court someone, if you invite them, it's a
Lordship,
dangerous thing for you.
Lordship, someone is
Someone କଲା
gives me
exactly ଆପଣ against ଦେବେ
the
danger is always think over it.
Lordship, 1 to 7, Lordship.
1 to 7 I'll give it, but
Right.
if you forcefully bring them to court,
There are
impose against you.
There are documents. They will prove the documents.
What do you say?
Vigilance.
What do you say?
Maharana is not there.
Here are small matter vigilance council. Ridgeway is there.
Maharana is on accommodation, my lord, up to 21st.
No, see, he wants to examine some defense witnesses, those who are private persons.
That's
That's right, but he says that they will not come. So court says that private person you bring.
Yes,
And he says that let me process be issued. And he is bargaining that risk. If you will bring them forcefully, they may depose against him.
What is the
That's good for you.
What is the provision, my lord, for issuance of process to the private person defense witnesses?
243, 243. 243, you see, there is provision. It does not, it does not dispute between private and public official.
He has a right to defend himself.
Yes.
He
243
is bargaining risk by calling them
243 subsection 2.
243, eh? Yes. 243. Right. Petitioner is agreed by the order dated 13/12/2024, whereby his application.
May I refer to 243 subsection 2 provision.
Yes.
When the accused has cross-examiner had the opportunity of cross-examining any witness before entering on his defense, the attendance of such witness shall not be compelled under this section.
We are not witnesses for cross-examination.
No, it's not. He's not asking for cross. He's not asking for cross-examination. He wants to lead his own evidence.
As my defense.
Rather, you will cross-examine them. Whereby his application. You are alone or how many of you? One accused?
Yes.
His application for summoning the private defense witnesses has been turned down. The petitioner, Mr. Moons, learned counsel for the petitioner submits that he has submitted the list of 9 witnesses to be summoned for his defense. Witness number 8
1
and
to
9,
7, Lord.
8 and 9 are the
8 and 9 are the wife. 8 is the wife of the accused, 9 is the accused.
wife of the accused, 9 is the
Accused himself.
accused himself. Therefore, he submits that insofar as the witnesses 1 to 7 is concerned, they may be summoned as the defense witnesses. He further submits that all the witnesses are the villages, rustic villages, and they would not come to the court unless
Summoned by the
summoned by the court. Hence, he seeks indulgence of this court. The trial court has rejected the application only on the ground that the witnesses are a private person. Therefore, the petitioner should bring them for deposition before the court as a defense witnesses. Mr. Moon, relying upon section 243, subsection submits that there is no distinction between a private person, private witness, or an official witness. Therefore, under the said provision, the trial court ought to have issued summons to the witnesses. Regarding being head to the facts of the present case and law facts of the present case, and inclined to allow this petition. Mr. Das objection level 1.
243(2) and 315. I object. 315 accused himself can be competent witness. 315 is there. Why accused will be summoned?
Prayer on the ground that it is the accused should have someone should have brought his own witness. The court should not be a party to the case. The court should not be a party to the case. Allow for the summon.
That's obliged.
315 provides that accused person to be a competent witness. Accused will be summoned by court to adduce evidence, my lord.
No, accused himself will be appearing. See,
Yes.
See, the larger picture, see, don't opposite the larger picture you have to see. The two things are very eminent. See, he is an accused, is facing the trial. He has a right to defend himself.
Yes.
Okay. And he doesn't have the control over these witnesses, appears to be. So therefore, he is seeking indulgence of this court.
No, my
And
lord,
in this situation, what will happen is he is bargaining the risk of forcing the witnesses to come and depose.
No, my lord,
Let him do that.
my respectful submission before your lordship that my learned senior friend is praying for summoning the accused himself.
No,
Accused himself is-
not at all. You have
He
not
want
heard the order. You
No,
have not
not
heard the order.
He is 315 rather.
Yes, my lord.
315 says the accused want to examine himself as his own witness.
Yes, my lord. He can be examined.
He is doing that.
Sir, you have not heard the order. This honorable court has directed that the wife of the accused and the accused will not be summoned.
They will not be summoned.
This honorable court has directed.
Obliged,
Yes.
obliged.
Yes.
My lord, your lordship kindly see page 21.
21?
21 of the brief, my lord. That is the
Yes.
that is the order of cognizance. Only 498. Parties are come, my lord. Now they have compromised.
Okay.
What
Are
happened?
they here?
The order of taking cognizance is 2014, your lordship. In the
What is the
meantime,
stage by the
Yes,
10 years
paragraph
have been
5, my lord. Paragraph 5, I will
Yes.
take till date, my lord. Charge are not framed.
para 5?
Paragraph 5, my lord. Last 2 line, your lordship kindly see. The case is pending for framing
Yes.
of charge.
Very good. Very
My
good. This is the expected.
my lord.
At least you should write what is the stage, because on your statement I can proceed.
Yes, ma'am.
Right on. At the instance, who all are they?
My lord, both the parties. My friend also.
Sarathi.
Because the petition was sent under 156(3), it has been stored, duly investigated, and for other offences. By that time, 304A and 302 was not there in that FIR, my lord. That has been duly investigated. That has been final form has been submitted. Thereafter, this case has been instituted. And surprisingly, my lord, no such occurrence has been taken place under the jurisdiction of neither of this honorable court nor under this police station, my lord. If fact is that a person has gone with their coaching friends, tutorial friends, along with teachers, picnic spot. He drowned there. He died there. To that effect, I had this petitioner has filed a missing report. After his dead body was recovered, the father of the deceased went there accepted the dead body and never spoke anything regarding this petitioner and others, and another person is there, that they have killed it, him or anything else. He has never spoke. And if 1cc case was filed, it has been sent on 156.3. It was registered. It was investigated. Final form was submitted. But that time he didn't say anything that 302 is there. Thereafter, my lord, after submission of final form, another case was instituted in shape of this complaint petition, in which cognizance has been taken. And
Where is that petition? Complete.
Page 12, your lordship, can glance for a moment, your lordship. Annexure 1.
This is a protest petition.
Yes.
no, my lord,
One friend is saying that.
yes, wait karantu.
Hmm.
Asibe.
Yes.
It cannot be said as a protest petition, as because the previous case does not include 302 and other offences. How if it is a protest petition, my lord?
No.
and
First 156.3 you show me.
Yes.
Where is 156?
my lord,
That is, your lordship, page
the-
find place in page 35, your lordship.
156.3.
Yes, your lordship.
Yes, my
This
lord.
is file and complaint case, the line
Where is that? Show me that.
35, your
so
lordship.
it's running page 35, my lord.
35.
Yes.
Yes.
36 includes the offences.
Yes.
420, 307. I may be pardoned. I said that 302 was not there. 420 was not reflecting in the present complaint case, my lord.
No, where is that?
Page 36, column 5, Dapha. I'm placing, my lord. Bharatiya Dandavidhi Ain no Dapha the 420, 307, 302, 109, 365, 34. But in this present petition, my lord, running page 13, offences committed 302, 304A, 109, 365, 367, 34 of IPC. If it is a protest petition, my lord, all offences should be dissimilar. No altercation can be allowed. How could he alter the offences by ignoring 420 and by adding 365, 367? Although no such occurrence has been taken place under the jurisdiction of this honorable court, under that honorable court, my lord. Nothing has happened.
Come to page 36.
Yes, my lord.
Read it. What are the allegations?
Nalisira
In-
Karana hai ki je- that this has been investigated and closed.
No, I know.
Yes.
Upadino Diba Barata Somere, Moro Sanopuo, Roson,
Aଜ୍ଞା।
ଫୋନ କରି ଜଣାଇଲା ଯେ ମୋ ଯେ ଭାଇ ରୋହନ
ଆଜ୍ଞା
ପାଣିରେ ବୁଡିଗଲା।
ପାଣିରେ ବୁଡିଗଲା। ମୁଁ ଅଧୈର୍ଯ୍ୟ ହୋଇ ପଚାରିଲି କେମିତି ବୁଡିଗଲା। ମୋ ପୁଅ ମତେ କାନ୍ଦି କାନ୍ଦି କହିଲା ଅନଙ୍ଗ ସାର୍ ଓ ଚିନ୍ମୟ ସାର୍ ସାନ ଭାଇକୁ ପାହାଡ ତଳକୁ ନେଇଥିଲେ, ଭାଇ ରାଜି ହେଉନଥିଲା। ଅନଙ୍ଗ ସାର୍ ଓ ଚିନ୍ମୟ ସାର୍ ବାଧ୍ୟ କରିବାରୁ ଭାଇ ସାଙ୍ଗରେ ଗଲା। ଅନଙ୍ଗ ସାର୍ ଓ ଚିନ୍ମୟ ସାର୍ ଭାଇକୁ ଧରି ସାଙ୍ଗରେ ବସିଥିଲେ। ଅନଙ୍ଗ ସାର୍ ଏବଂ ଚିନ୍ମୟ ସାର୍ ଭାଇକୁ ପେଲି ଦେବାରୁ ସେ ପାଣିରେ ପଡିଗଲା। Thereafter, after this,
merely because section is not there, therefore you can't say that there was no allegation.
no, my lord, I'm convinced.
Yes.
Thereafter, one UD case was registered after the body was recovered.
Yes.
In that UD case, he has never
All
stated.
these things are evidence, sir.
Yes.
All these things are evidence to be adduced on the right time.
Ye-
There was allegation.
but-
There was allegation
but
that
this case was closed.
I know investigation is completed,
Yes.
closure report is filed,
Yes.
and the informant was not happy, so therefore he filed protest petition,
Yes.
and he brought some evidence. What to do?
What evidence he has?
Let
brought,
us
my
see now.
lord?
Let us see.
Yes.
Let us see. You can't say there was no allegation. This is
I'm not saying
Let
that.
us come to protest petition. Where is that protest petition? Which page?
Page 12, your lordship,
Yes.
this is relevant page, your lordship, that is 14.
14 years. Read it.
It's clearly stated that the final form is submitted is a mistake fact, thereafter. the
No,
present-
come to page 14. Para
Yes.
para 8.2. That the
8B, my
complainant
lord.
who are aggrieved.
Aggrieved persons because of the improper lethargic
lethargic
and biased
Investigation.
biased
So,
investigation of
therefore,
the
it is a
investigating
protest
agency,
The investigating officer
Yes,
in the.
yes, enough. Therefore, it is a protest petition. He's not happy with the investigation.
Yes,
Let us come to the allegation.
may I drive your lordship to page 40, annexure 4?
Let us read the first complaint, whether what are the.
Yes.
Yes, page 16, middle. Middle, yes. Reiteration of the same allegation.
But
Same allegation. And para E.
para email.
On 28/12/2018, complainant number 2 and his brother, Roshan so and so, along with so and so, Ananga Uday Bal and Chinmay Das. Same allegation.
Yes,
And 202 statement. Show me.
202 inquiry report is not with me.
202.
Nahi.
It must be a reiteration of that.
202 inquiry report is not with me, my lord.
I'll pass the order. Huh?
But your lordship,
I'll pass the order.
kindly have a glance to page 40.
40?
Yes, annexure 4.
Yes.
That is the UD case report.
Yes.
In that UD, after the first complaint case was filed and registered, investigation was going on. By that time, the UD case was registered. And in that UD case, which was registered at Thakurmunda police station, the complainant didn't speak anything that I have pulled him. He didn't speak. He said that he has his son.
Who is the complainant? The father is the
father.
And father heard it from the younger son. That time he was not aware of all this.
45 days. But he was recovered
in the last 3 lines, he says that.
Yes. After 45 days.
All these things
this UD case was registered after 45 days. And though no occurrence was taken place in the district of Cuttack, it's an offense under section 302, my lord. No occurrence took place. The jurisdiction.
Yes. I'll pass the order.
My lord, I am appearing for the OP number 2, who is the father and the complainant in the previous case. So, my lord, I have made the same allegation before the IIC Madhupatna, and subsequently on 5/1/2019, the complaint case was filed and the complaint was sent to the IIC Madhupatna for registration of the FIR. However, after 35 days of the case was filed. The entire process, the entire investigation process was tampered by the present petitioner. Even after, my lord, the cognizance was taken by the Honorable, by the Learned JMFC City, he did not appear. And however, your lordship may have a glance to the NBW.
That is neither here nor there.
NBW.
Appeared or not.
My lord, in the case in hand, it is seen that the summon of appearance of the accused senior.
That's neither here nor there. Whether he is appearing or not, the other consequences. The specific allegation made in 156(3).
Specific allegation
and
made
specific allegation made here in
protest petition, my lord. And however,
so therefore,
after due occasion, even if the minor child was major right now, who is the opposite party number 3, he has deposed everything what has happened on the date of occurrence before the trial court.
Have you examined that minor boy who is the younger brother of the deceased under 202?
Yes, he has been examined.
Where is that sit?
My lord, that is not with me, but I know that he is examined.
Whether
yes, he is examined.
Examined. What is her version? His version. Because you were there.
His version was, my lord.
Do you have that? Have you read it?
I've read it.
Show me that. Give me.
Presently, that is right now.
That's the only witness who can tell the real truth. Was he examined in 161?
My lord.
Do you have that?
Presently, right now.
You are not prepared at all. See, that is the two piece of evidence you have to give. 161 statement of that boy and 202 statement of that boy.
My lord, the matter may kindly be kept, tomorrow I'll bring the document.
Tomorrow I
Tomorrow. Next week, your lordship,
If you are opposing, you should have come with
My
that.
lord.
your lordship, keep it next week.
Keep it next week. Yes, next. Partly heard. At the stage, the counsel for the petitioner as well as the opposite party submits that they would be producing the statement of the witnesses recorded under section 161 CRPG as well as 202 CRPG. Please.
NBW is issue. NBW is issue.
We'll see. And then see, that is what I'm saying. Was the NBW, go and appear. It is a case for bail. There is no doubt about it. You'll get the bail and move application. That is the best thing. That is the best solution I'm giving.
I will face the trial. I will face the trial.
Because I will set aside this thing. Because see, these are twice it is investigated and he is entitled for bail. There is no doubt about it. And face it. Show me that. 14 na?
13.
13? Right. Petitioner is agreed by the order dated. Cognizance order. Where is that? Page
23rd, 9th, and 24. Your lordship,
Page
59. Page
2309.
39.
59, your lordship.
59.
Page.
Order
Annex H.
dated 23/9/2024. Passed by JMFC Cog taking 4 Cuttack.
My lord, another co-accused in custody.
By the cognizance of offences punishable under section 302
and the other offense 302
302/201/34 IPC taken against the petitioner on the protest petition filed by the opposite party number 2. Initially, the opposite party number 2 had filed an application under section 156 bracket 3 of CRPC on the basis of the direction of the magistrate, direction of the JMFC city Cuttack. FIR was registered corresponding to FIR number.
Initially, FIR has been registered as
Initially,
FIR number 17 of 2019.
17 of 2019.
Madhupatna PS case.
Madhupatna PS, corresponding to GR case number
282 of 2019
for alleged offences punishable under section. What are the offences?
Offences are 420,
420,
307, 109, 365 and 34.
After investigation, the closure report has been filed by the police. Agreed by the closure report, the informant of the opposite party had filed the protest petition. I have filled the protest petition. Especially as primary against the petitioner. From the statement of the witnesses recorded under section 202 and the government made in the complaint, protest with the complaint of the protest petition under 200 KPPs. The court below has taken cognizance by the impugn order. The petitioner is seeking the indulgence of this court at this stage for quashing of the same. The counsel for the petitioner submits that pursuant to the cognizance order, pursuant to the impugn order taking cognizance, the court below has also
5322.
NBW. Where is the NBW? By the order dated
2309/2024.
order dated 23/09/2024.
Yes.
24. He further submits that instruction submits that his client would be appearing before the court on or before 20th of March and resort to the remedy available to him under law. He submits that in view of the nature of allegation and the evidence gone on record, he is away and not expressing any opinion regarding the case. However, the liberty is granted to the petitioner to urge all the points before the court below at the time of proceeds the plea of bail, plea of bail. If such application is no, same shall be considered on its merit, Till then, no course action shall be taken against the petitioner. 20th March, no course won't appear. And I set aside the remedial law. I set aside the remedial law.
Direct that the magistrate is not having jurisdiction under section 3
Same day, if application is moved, the same shall be considered by both the courts below, on the same day. Yes.
Lordship, may kindly observe one more thing, my lord.
Yes.
The year is closed. The previous course final form is already submitted.
That I have written.
That has.
That I have written. Yeah, this is a case for bail. You get the bail. No?
But your lordship may direct that in.
I can't direct, but I have made enough observation for bail.
But they will put objection, and then again this person will be.
See, I have made enough observation. I think this is a bail. This is a case where you should get bail. 100%. You till 20th of March. In between, you go. Okay. Yes.
14.
If you want, I can give you little more time. Let it be 30th of March. Because you are a teacher, in fact.
Yes.
There is only oral evidences.
Yes,
There is no medical evidence, nothing is there. So you get 30th. Okay. Enough time I have given. Yes.
May I please allow?
Yes.
Quashing of cognizance on the ground of compromise, Your Lordship.
Offense, sir. Offense.
Offenses page 59, so 147, 140, 341, 294, 506,
Yes.
323, 336.
What are the allegations?
Allegations, Your Lordship, the present informant has a liquor shop and the villagers were protesting the same. On that score, the FIR has been lost.
What are the allegations? What have you done?
The allegations of page 15, Your Lordship, the Nivedan Abhipraya है कि जे मोर सरकारी लाइसेंस प्राप्त चिल्लिका फूड एंड रेस्टोरेंट
धमक देला पथर गोटे आनी मुंडे
समय अतर्कित भाव किसी आंटी सोशल दुर्बृत्त माने आसे मत असुविधा गाड़ी गुलो करी गाड़ी गुलो परिया सहित फेका पथर मो ऊपर को फोपाले एवं दुकान ऊपर को मते फोपाले मु सेमाने मना करिवारे सेमाने मते टाणी नै रोड ऊपर विधायकटा मारी तळ पकाई विधायकटा मारी तळ पकाई देले
You have a liquor shop or he has a liquor shop?
Minus
Who has a liquor shop?
the informant, Your Lordship. The present petition.
Now you become a potential customer.
No,
That
my
is the
lord.
settlement. That is the settlement.
Young boy, Your Lordship.
Okay. And do you have any objection?
No, in paragraph 13, they have about that they have settled the matter. But in another case, next case, in similar, these similar accused persons and these similar informant.
Next case in 15.
307 is there.
15.
15.
Yes, item 15.
Let us see first 14. Let us see.
Yes.
Let us complete 14. In 14?
Yes.
14. The instance of opposite party number 2. What is the stage?
Is the Lordship cognizance taken? Charge
They
not.
have challenged the cognizance.
They are there. They have the
Yes,
thumb.
Lord.
Digambar at Jagan Vish.
Digambar.
I didn't see the opposite party number 2. If I am so came to the business, allegation after investigation, charge sheet has already been filed in the case, and the SDJ Puri has by the order dated. How many of you are there?
22 accused persons are there.
So then,
ye hela accused number 10. The petitioner is one.
You can't choose.
No, the present petitioner, Lordship, young boy, Lordship.
A young boy maybe, but the complainant doesn't have the choice of choosing one accused and settle, and the other people will suffer. This is not permissible.
They will come later, Lordship. The
No. You either you settle with all or you don't settle with all. Don't settle. But the complainant doesn't have the choice of choosing one accused. I will settle with him and but I'll proceed
the
again.
difficulty is, Lordship, the other accused, they should come to the complainant, Lordship. They are not pursuing for any settlement, Your Lordship.
Then it's a very difficult thing.
No, my Lordship, I have two judgment, Your Lordship, one of this Honorable Court and another from the Honorable Appeals Court, Your
So,
Lordship.
give me.
It can be.
Give me. Yes.
In
Which paragraph?
our High Court, Your Lordship, last paragraph,
Yes.
paragraph 6, Your Lordship.
6, huh?
Paragraph 6, next page, Your Lordship.
Yes.
Last page.
Yes.
Middle portion, the Honorable Supreme Court in the case of Rajasin Rana accepted the compromise between the informant and a particular accused and quashed the proceeding in respect of that accused, internally holding that in view of the settlement arrived between the informant and the accused, there is no chance of recording of conviction in as the accused is concerned and the entire exercise.
What are the offences here?
Here, there are Lordship 420 and the other offences.
365, 464.
Yes, Lord.
307 was also there. Okay. And next?
Next judgment, that is that judgment to which the
relied upon.
Relied upon.
Where, which
there is para 9, Your Lordship.
9?
That's only middle portion. Further, in view of the settlement arrived between the respondent 2, the complainant and the appellant, accused number 3, there is no chance of recording conviction. Accordingly, there was also one accused was there. Accused number 3 was filed the compromise petition, Your Lordship.
What are the offences here?
Here, 467, 468, 471, 420, and 120B of IPC. Para 6 of the judgment offences are there.
So, Odisha High Court judgment will help you because see, these are the Supreme Court judgment may not help you in the sense these are the offences against the individual. So therefore, the court says that the individual offences, so then therefore it can be quashed. But the offences for which you are being tried are offences against the society. So therefore, the High Court order is the 307. This will help you. This will help you. I'll rely upon it. Right. And white order dated 28/6/2021. The learned SDJM Puri has taken cognizance of offences punishable under section 147 or 341 or 294, 506, 323, 336, 149 IPC. 49 IPC against the present petitioner and 21 for the accused person. The was entered into when the trial has before the trial is commenced, the informant is entered into a settlement with the present petitioner who is arraigned as opposite arraigned as what is his name? Jagan Vishwa. Jagan Vishwa.
Number 2.
Jagan Vishwa. Accused number
10.
Jagan Vishwa.
10. The learned counsel for the petitioner submits that as per the submits that the informant submit that the case of the present petitioner could be request on the ground of settlement, although the informant has settlement present petitioner leaving the other 21 accused to suffer the trial. He has relied upon the judgment of this court decided in one part so and so para 6, para 6. Relying upon the judgment, that on the ground of compromise, the court can exercise jurisdiction under section 482 CRPC, watching the criminal prosecution against individual accused, leaving other accused to face the trial. The case of the petition is clearly covered by the judgment of this court in B. Satish Reddy Super. No, therefore, therefore the petitioner deserves merit. The opposite party number 2, who the informant has filed an affidavit before this court dated 17/2/2025 inter alia stating under para 2 to 4, para 2 to 4, para 2 to 4. On query from the court, the informant opposite party number 2 submits that he has entered into settlement with the present petition, and he also submits that the other persons have not come forward to settle the dispute with you. Dispute. Therefore, he had chosen to settle the dispute vis-a-vis the present petitioner at this stage. Mr. Vishwal and counsel for the state submits that there are total 22 accused persons. For the accused number 10, that is the present petitioner, the intendant chosen to settle the dispute. But he doesn't have any contrary judgment to dispute the settled position of law. Contrary judgment, settled position of law. Hence, he submits that this court may grant indulgence to the present petitioner on the basis of judgment of this court in certain or super regarding two forms of this.
Lordship may say that this confined to only Jagan Vishwal.
Yes. The present petition. Yes.
Obliged. Item 15, Lordship, I pray 1 week after.
15.
Obliged.
May I please, your lords?
Yes.
Lords, this impugned order is framing of charge at page 39 relevant, my lord. 13/1/2025.
39.
Page 39, lords.
Yes.
Here, these petitioners were earlier before your lordship, my lord. The lordship granted liberty to the petitioners to agitate all points before the court below, my lords. And here, my lords, it's a case, my lord, where there is injury is simple, my lord, but the 307 is there, my lord. That is, it's a between the neighborhoods, civil dispute is there, and there is, my lords, no motive, my lords, and injuries, and no weapon of offense also seized, my lord. When ingredients 307.
Had you have moved the application for discharge?
My lords, earlier I had approached this honorable court in that page that is there, my lords.
Page 31.
Page 31.
31.
Yes.
1 minute.
5/10/2023 order.
31. 1 minute.
The relevant page is 33.
Yes.
In the present case, cognizance are already taken for offense
Yes.
307.
Against the cognizance order. You
Yes.
came.
Now, here, no, in this order, that was rejection, my lords. This this was rejected, this was rejected, consideration charge was there fixed, my lord. That order I was challenged before your lordship, my lord.
Now charge has been framed.
Yes. And your lordship's order is that at page 41, lords.
Okay, 41.
Yes, lord. I challenge that rejection, my lord, and I approve this, your lord.
So this petition was against what? Which order? Cognizance order.
It was rejection of the discharge, rejection of discharge.
Discharge.
Yes.
And I gave a liberty
Yes,
to argue
yes.
that
Thereafter, my lord, it was the judgment of this honorable court was placed, and since this order is there, my lord, that's oral arguments were made along with a judgment of.
But there is no reasoning given in the,
Yes, my lord. Yes, they have passed this order, my lord.
there is no reasoning in the impugned order.
Even on the last order, my lord, an order is there, my lord. The learned court, my lord.
Let us see. Let issue notice. We'll see. Because see, in the impugned order doesn't say anything. Simply issue
I
notice.
find there is sufficient ground for
But that's all.
assuming that the accused persons have committed such offense.
That should be the last paragraph after discussion. Every discussion, that should be last paragraph.
And filing of this earlier case was very much in the knowledge of the.
I'll just issue notice. Let us, yeah. Issue notice.
That is the IA matter is fixed tomorrow, my lord. This order is
You
there.
move application for that.
Page 39, it is fixed to tomorrow.
Okay, you move application. I'm giving
Yes.
that liberty. Yes. You will move application going to the potential. Yes.
Grateful, sir.
Vigilance. Lord, this is an appeal against a conviction. The conviction under section 13(2) of the PC Act.
Sentence, how much?
Sentence.
2 years on each count. Three offenses. 2 years
Yes.
on each count.
Yes.
2 years on each count.
Yes.
My appearance may kindly be noted, my lord.
Yes. That's appearance.
Bail state realization of faction.
A free copy be given, my lord. May I pray free copy?
Give a copy to Mr. Das. Okay.
May I please your lordship?
Yes.
My lord, this is against the order of rejection for release of my passport, my lord.
Passport.
Yes, my lord. My lord, your lordship may see annexure 3. Earlier, my lord, on 16/10/2023, pursuant to the summons by the trial court, I appeared and released.
Let me issue notice.
No, my lord, your lordship may kindly see, my lord. My lord, I have to travel because already my passport was released once by your lordship. And I traveled last on November 4th November. I surrendered again my passport. My lord, I required to travel because there is the exhibition, Vision Expo exhibition, which is scheduled to start on 19th of February. I have some business meeting in UK, and thereafter to.
What are the offenses?
Offenses, cheat fund, 468 and 4 and 5 of the price cheat money. My lord, your lordship, annexure 3, your lordship may kindly see. Earlier I approached your lordship allowed my revision. My lord, basing on that, again I approached the because of the contingency, I approached that let my passport be released for an interim period, but that has been rejected, relying on his own predecessor order and saying that the judgment passed by the High Court is not applicable. My lord, my case, I got the order. My order is not applicable. Your lordship, he has followed the order passed by his predecessor while rejecting. Same order he followed that the High Court order is not applicable. And in the meantime, my lord, in one case, the co-accused, your lordship has also granted interim pending disposal of the application. Your lordship.
How many days you want to go?
I want to go for 2 months maximum. 2 months.
For business trip, what will you do? 2 months?
Maximum.
You said you are going for exhibition. 2 months there is no.
Maximum to 2 months. Maximum to 2 months.
But when the exhibition is there, when it starts?
Starting on 19th of February and it will continue for a month. And prior to that, I have some business meeting in UK. And that exhibition is starting on at Austin in USA. So 2 country I will be back by first week of April.
US and UK. Last time also you visited.
Yes.
Your lordship, I need time for instructions in the matter because your lordship, I
Already
don't know
that
where he was to go. He is a charge sheeted accused under
I
460.
have filed IA. Let him file his objection.
Only your lordship day before yesterday served me. Your lordship, I need instructions in the matter. These are sensitive matters, your lordships.
No, I have filed a IA.
Yes, I am giving a short take. Issue notice, Mr.
Because already I have lost 2 lakhs rupees for ticket, my lord. I booked the ticket.
Got an order, then book ticket.
You have earned more.
My lord, your lordship.
Why do you worry about?
My lord, kindly see. My lord, once your lordship.
I understand it.
Your lordship, kindly see.
Yes.
Once your lordship has already decided this issue. And prior to that, from 2016 to 2023, I have given my travel history. When even during pendency of the investigation, even after submission of the charge sheet, I have traveled. The Supreme Court, Honorable Supreme Court has said that keeping in view the travel history.
No. The only thing is you repeatedly going to the same destination. Therefore, they have to verify. Why for you are going there?
No, because of my business.
If you would have gone to some other country, I can understand. Repeatedly going on the intervention of court, going to the same destination.
But because of my.
And they need to know why you are going to that. And you say that exhibition. Show me anything on the exhibition.
Yeah, I have mentioned.
Exhibition is for a limited period.
Yeah,
you want to go to USA, thereafter UK.
No,
the same thing you have done earlier also.
Which annexure, your lordship? Which annexure is exhibition?
Yes.
So therefore, earlier you had gone to the same 2 countries.
Because of my lord business.
Whatever business. So therefore, they need to verify why are you repeatedly going to the same destination. Therefore, I am issuing notice. I'll put it after a week.
My lord, again.
Your lordship, these exhibition documents are not annexed. Which exhibition?
Interim.
No. Interim is final.
I have filed.
Interim is always a final.
Why I say so, my lord?
Okay, 21st.
Let it be on 19.
So 1 week time, your lordships. At least 1 week time, your lordships. 1 week time.
Again, he'll ask for
Already,
Your
your
lordship, I'll again ask.
objection is already.
you show me when the exhibition is fixed.
19th I have mentioned, my lord. 19th of February I have mentioned.
Which page?
Because my lord, what happened, my lord, why I am going, I am just telling you, my lord, your lordship. My lord, my senior.
Why have you come at the last page?
My lord, what happened, my lord? My senior manager, who is in charge of US office, suddenly his daughter died on 25th of December while undergoing treatment at Kerala, my lord. He has to return back to India. So there is no senior person there. I being the CEO, I have to be there. My lord, that is the whole thing I have stated. Not that I am going for a pleasant trip, my lord. Your lordship may kindly see. I have mentioned.
Death certificate of the doctor and.
Okay, 20th.
But so at least 5 days maybe. Your lordship, at least 5 days time maybe given. Again, I will seek time, your lordships. 5 days.
19th is the day. I am giving 20th. What to do? Because
already, my lord friend, I have already.
Exhibition document. Your lordship may see the annexures. Where is the exhibition document? Where is the death certificate of the
document
doctor? Already you can't tell anything, your lordships. Which exhibition, your lordships? Some invitation must be there, some mail must be there. Only by saying exhibition, your lordship. Which annexure, your lordship?
You take it that he is not going for exhibition. Take it like that. Let him go. You just verify because I am only giving this opportunity because he is going to the same destination.
So only 1 week time may be given. 1 week time.
That's why I am giving that.
So 1 week time.
Let it be
1 week.
Let it be Monday. Okay.
Okay.
Attend that. But I have, because I just spoke to the person, but since this March is coming, my lord, I have to explore my business because the year end of March, I have some clients in UK and US.
That's why I was telling 20th.
So your lordship may call it on 20th. The 24th, my lord, would be too late. Because
you inform Mr. Naik.
I will inform.
Yes.
Either 20th or 21st, your lordship.
21st, inform, huh?
I will.
Yes. I will. Yes. Inform him.
And I will also, my lord, file that additional document.
NBW was issued on 22/8/2022.
Dated 21 August 2014.
14. Speak little louder.
And the NBW dated 22 August 2020.
23. Okay.
22.
22. 1000. Yes.
20 urgent certificate copy may be granted, man. Urgent certificate copy may be granted.
Yes. Yes. 20.
Item 20, the police was in the petition was in police bail, my lord. The summons was issued that on duly served, my lord. On 2/9/24, enrolled has been issued.
2/9/2024. VW police on police page. Police. Yes. 20/24. 500. Yes.
21.
21 May result. My lord, NBW issued on 23/2/2024, my lord. And he was on bail on dated 28/9/21, my lord.
21. Oh, 500. Yes.
22.
7/12/2018 बेल 12/1/2023 NBW.
Yes. Bar 22. Yes.
NBW order dated 12/1/23, my lord. Petitioner was on bail on 7/12/18.
Okay. 500. Yes.
23.
Case, my lord. The petitioner could not know about the issuance of NBW.
Sorry?
Of course, that is date 20th of July 2015, my lord.
12/2024. Non-appear, therefore NBW was not executed.
What are you saying?
20 July 2015 to 12 2024. The last date. No one appeared.
The NBW was issued on 20th July 2015, and which could not be executed. Hence, a fresh NBW has been issued by the order dated
2/12/24.
2/12/2024. 2024. Bail, all of them are bail.
Bail, my lord.
They give the dates.
That is in para 5. They have mentioned.
Para 5. Para 5 लिख दो.
No date was.
Date. In
No,
fact,
date is not there.
Date is
bail order. 1,000 for the case.
Madam, NBW dated 22/10/2024 and bail order 1/2/2024.
24.
Well, a 25-year-old case, here bail on 7/8/2003 and NBW on 19/4/2011.
11.
My lord.
2000. 2000. Yes.
Well, labor class 1,000,
Next.
1,000.
Next.
26 my lord, bail dated 2nd March 2020 and NBW dated 12th March 2024.
24. Okay. 500. Yes.
NBW 4/1/2025.
25. 500. Yes.
28 by law, previous bail dated 15/4/2014. The NBW 21st/6/2022.
20.
21st/6/2022.
22. 500.
So I have filed this application, my lord, for any execution or NBW, my lord. Kind have my lord, glass, my lord. On 16/4/22. Yes, yes. 16/4/22, my lord. Directed to give 10,000 per month to thereafter.
I'll have to issue notice then.
No, kindly glance, my lord. Not record. Kindly glance, my lord.
Yes.
That what happened, my lord. Kindly glance. Till date, my lord. Annexure 4, my lord.
Yes.
Till date, my lord.
In execution proceeding.
No, execution.
I know.
Of NBW.
But in the DB execution proceeding, NBW has been issued.
DB execution proceeding,
Then
execute the NBW here. What I'm something kind of.
therefore I have to issue notice.
Direction SP को देते लगे तो क्या बांधी गए तो पैसा दो एती करा से दास नहीं इट इज नॉट से हेगलान देखुंते 2025 पर्यंत.
Okay, right. Petitioner is the informant. No, petitioner is the how many petitioners? Petitioners are petitioners have initiated DB proceeding against the petitioner being DB case number.
DB case number, my lord, 258/20.
258/20. There are some interim maintenance order was passed by court below. The maintenance order has not been complied by the opposite party. Hence, the petitioner initiated DB execution case number 366 for 2022. In the said proceeding, and because of the absence of the opposite parties, NBW has been issued by the order dated 28/10/2020. Mr. Mishra and counsel for the petitioner submits that despite the fact that the NBW was issued 2 years back, more than 2 years back, the NBW has not yet been executed. Which police station executed? The police station. Police station.
Both two police, one Jagatpur and another. I am residing Jagatpur. He is residing Salehpur, my lord. OP number 5, my husband.
Which police station has to execute? Unless you tell which police station.
Salehpur,
it'll run around.
No, Salehpur, Salehpur.
Mr. Mishra submits that the execution of the warrant issued by the court of JMFC R Cuttack in DB execution case number 366 for 2022, wide order dated 28/10/2022, needs to be executed through the IIC Salepur police station. Regarding head to the facts of the present case, since the maintenance order has not been complied with, the petition deserves urgency. Hence, the IIT PS Salepur is directed to do and to think that the executed as expedient as possible. Yes.
Milord, one thing, but unless until that directly they are only DCP directed, Milord. Again, Ketetor Helen, the Kuran, Kodia Posista.
Let us see now if there is a direction from the High Court, it will be done. Don't worry. Yes. Otherwise, I have to issue notice.
Another thing, kindly paste 10, just now, paste 10.
Yes.
Ordering portion.
Yes.
IHE Jagatpur and Salepur Kotak, both he directed for both the police station, Milord, to execute the. So only only DCP directed, Milord. Then both are coming.
What do you say? What do you say? It is your job. You have to execute the warrant.
Again, 10,000 taka diya hai 6 ବର୍ଷ lag fine.
All these things, forget about all these things. Maintainability and all. There is an NBW, you have to execute it. As simple as that.
Yes.
Here, my lord, execution process to arrest the husband.
Yes.
There is an NBW order by a court, competent court. Is it not your responsibility to execute it? Why should you force people to come to the court? You should not force you create that situation that people should come to the court. And all these matters are pending because you are not able to execute the. Therefore, the people are coming. Please tell the NBW we will go and appear. This is so. Therefore, the state should not oppose it. Rather, state should facilitate it.
I am not opposing my. It is better to your lordship direct to the DCP.
Yes.
DCP which area?
DCP Kotak, Milord.
DCP Kotak.
You will execute the.
Execute it.
Public.
And the law will take its own course, whether he is has to pay or not to pay. That will be taken. Yes.
30.
Yes.
30.
DCP.
81.
Yes.
8125 NBW.
8125 NBW. And
bail only he has mentioned, my lord.
He is on bail for 500. 31. Yes, sir.
No,
31.
I am put 33.
What kind of review petition? There is no order also. Please file this. Impure order is also not there. There is, yes. Who is appearing? What kind of petition is this? 2003 it is pending. Huh? 1995 OJC. 2003 the review petition. And in the review petition, nothing is filed. Not a single annexure, including the impure order. Pending. Pass or issue. I'll pass it over and anybody I'll display. Yes. For non-possession.
33.
33, my lord, 159 delay.
Delay. 33. Anybody there? You are appearing?
My lord.
I am
33.
Yes. 33. I am for the respondent, Milord.
Yes. Yes.
159 delay, my lord.
What are the explanations? So, yes.
The official.
Yes, sir.
Paragraph 3, my lord.
Yes. Yes.
Certified copy of the judgment passed in WPC number such as the office of DEO Sundargarh.
Same file went to this court. There.
But my lord, this case, my lord, the opposite party has never promoted to the post of my lord. Only he take charge as a HM.
No, show me the error then. Show me the error. Show me the error.
Error, my lord. Here, my lord, the single judge, my lord. Lord, court, my lord. Has refer the judgment is not, my lord.
Which is that order we are seeking for review?
Yeah.
Order dated?
Order dated 11/5/2015.
Yes, yes,
WPC number 8861 of 15, madam.
yes. Hmm.
The appellant in the side, this judgment was not, my lord, is applicable to the petitioner's case, my lord.
Which one? The Selvaraj?
My lord.
Yes. Why?
Not review, my lord, we have mentioned that, my lord.
What about Dilip Kumar Sahu? Yes. What is Dilip Kumar Sahu? Whether case is covered under Dilip Kumar Sahu?
No, my lord, Pavitra.
I think you have not prepared.
My lord, delay, my lord.
No, no, no. If there is something on merit, then I'll entertain. Otherwise, on the ground of delay, I'll dismiss it. Therefore, you tell me on the merit whether you have a case.
My lord, no. The present petitioner, the opposite party, my lord, in view of Pavitra Mohan Das versus State of Orissa reported in 2001 Supreme Court, an assistant teacher should be eligible to be promoted to the post of headmaster in an aided institution.
That you are going on merit.
My lord.
You simply tell me where is the error. Show me the error.
Error, my lord. The ground of my lord. The Lawrence George, my lord, cited the decision is not applicable to this case.
Then you have to go to appellate court and say, where is the apparent error on the record? A wrong judgment is relied upon, according to you, and
and he has never been promoted to HM, my lord. He was the in charge of HM.
Where is the finding that he was promoted? Where is the finding? Come to the second paragraph.
Order, my lord.
Come to the second. See, you have to see the judgment and find out the error in that. Show me which part of the judgment is erroneous, which is contrary to record. Show me that. Merit, you may have a good case. Then you have to go in appeal. You have not prepared, then prepare it.
Yes, ma'am. Next week.
That's a better idea. Otherwise, I'll simply dismiss what is you.
If your lordship
permit, I'm thinking of, my lord, only delay.
No. See, you are the state. You are seeking review of a judgment which has been passed in favor of him. So be more careful. Why should the state will come and review? Review means, review jurisdiction. Apparent error. You are saying that the honorable judge has committed an error in the judgment, apparent error, contrary to the record. You have a larger responsibility to show. Because some judgment has been passed in including, in his interest. So therefore, larger responsibility. I'll put it next week.
Kindly respond on the delay, my lord. Put on
the delay he is opposing.
Yes, kindly. My
Postmaster General.
Yes, mas. Yes,
Postmaster General.
Yes. That is enough.
You will recite, I know that.
That is enough.
You have to get over Postmaster General.
And recent judgment also.
Postmaster General is very specific. Very specific. You have to get over that also. If you have a case on merit, then I may consider and do it. If you don't have a case on merit on the ground of delay,
according to his statement, delay is 160 days. Near about 6 months, 5 months. In my friend stated that the post is not promoted, but I am not promoted. My post is not promoted. I am not promoted to the post of headmaster.
But you were working as a
yes, my
that's what Dilip Kumar Sahu is seen it.
Yes, you lordship. Initially, I appointed as a headmaster.
I understand. I've seen it.
But the government approved my post as a headmaster in charge. How? I appointed as a headmaster. If he did not approve as a headmaster, then he approved as an assistant teacher. How they approve the in charge, headmaster in charge, my lord?
Let him prepare.
3 coordinator judge.
Let him prepare. I can't hear today.
No, more khali tikke apu
why to waste time?
Judgment
next time.
That may fix, my lord.
Date will be fixed. Yes.
Get the cabinet.
It is his petition, let him satisfy.
Yes, my lord.
Why are you
No, I would like
unnecessarily creating a problem for yourself?
Your lordship last time
Let him satisfy.
Yes,
Last
my lord.
time, my lord, I am.
Yes, my lord. Yes,
His
my lord.
petition.
I have no.
Last time I am.
Not that he will give.
Yes, my lord. Because he is not receiving his pension,
Not
man.
to the first week of the Yes.
Item
Yes, madam.
34 Lordship, the respondent number 3 died. So I took time to file the substitution application. Save 1 week.
Submits that the respondent number 5.
3
has expired. So therefore, necessary the petitioner would be taking necessary steps to bring LRs on record. LRs on record. LRs on record. And last opportunity is granted to the petitioner to take appropriate step to bring LRs of respondent number 3 on record. Yes. Yes. 35.
5, my lord.
Yes.
Covered by your lordship. Yeah.
Good. Again, in the delay ground. Delay ground.
Postmaster case.
Good. Yes.
36. Item 30 Belgium I was unable.
I will increase the cost because you are absence.
Because my associate.
Yes.
36.
36. Yes. 36. Yes, sir. There is no delay.
PMAPL.
Restore. FAO. I'll allow it.
36 minutes I am there.
I'll allow it. There is no delay.
No delay.
Okay.
Only code is to be indicated.
For the reasons stated in the application, the so and so is allowed, and FAO number 173 of 2023. So the order dated so and so is set aside, and FO is restored to its original position or original file. Leave FAO. Yes. Next.
Yes, sir.
Yes, sir. Yes.
My lord, we have filed the NOC and I may be permitted to appear for Mr. Hota, my lord. Asine, but your lordship.
I'm simply urgent.
No, my lord can allow the application and restore the file to its bail appeal.
Oh, bail application.
Bail to dismiss it.
Bail application. You can file a dismiss in the court.
My lord, protection thilla, that is why interim protection thilla.
For 90 days. Matrimonial.
Matrimonial.
Okay. For the reasons stated in the application, the CRLM is allowed. That bail application number, what is that?
2077.
ABLPL number 2077 of 2022 is restored to its original file. At least the ABLPL number so and so before the roster bench. Okay.
My lord, till then the interim protection may kindly be extended.
If it is there, I am restoring. I can't touch that file. I have restored.
My lord, till the order is passed by the court.
This is only CRLM. I am allowing it.
Gratefully,
I can't say anything. Interim order is there. Interim order is there. I restored to its original file.
Your lordship.
Yes.
Yes. My lord, what had happened was by order dated 7/12/2022, specifically, my lord, the interim orders were located. If this order goes, my lord,
move application because I can't touch AVAPL
as a lordship
petition. Because I have allowed your petition fully. Correct. And you go and tell that.
Correct.
Yes.
CMAPL.
Yes, sir.
Dismissal of contempt petition 8272/23. Non-procedural, non-application.
Content petition.
Next up, okay, John. My lord, director.
Actually, the contempt petition should not be dismissed for non-project. Because in the contempt, you have no role to play. It is between the contemptor and the court. You have just informed the court that, see, you have passed an order, it is not complied. Then it is the court's business. You are only, you are supposed to inform the court. So it should not be dismissed in the court in due respect. And then I'll restore it. Okay, I'll restore it. For the reason stated. Sorry. Yes. So therefore, if I will not restore, the petition will be hit by limitation, 1 year limitation. So therefore, it shouldn't be dismissal for non-prosecution. Yes, contempt petition should not be dismissed. Yes.
May I please, your lordship? Lordship,
Sorry.
this is a same appeal application for restoration of the same appeal number 70 of 2011.
Same appeal number
70 of 2010.
delay, how much you think?
35 days delay, your lordship.
35 days.
Yes, your lordship. In IA number 591 of 2024.
Then private party,
Yes, your lordship.
I'll have to issue notice. Issue notice, yeah? Issue notice on application. Yes. Yes. Yes, sir.
May I please, your lordship? This is a prayer for cancellation of the bail granted in favor of the opposite party in BLA PL 4037.
What are the grounds, sir?
My lord, the ground was that there was suppression of the fact that there was a necessary party. The Narcotics Control Bureau was the necessary party. And we were not made a party. State of Odisha was made a party instead. Therefore, we did not get a.
Where is that order? Granting bail?
My lord, that is at Annex 5.
Right. What is the story?
Something what is the commercial.
What is this case?
Hello, he is out on bail.
No, stage of the trial. Is participating?
No, my lord, he had given a this thing, he had given an IA that he is actually resident of West Bengal. So he wants to not appear before the, he is having.
I issue notice, let us. Issue notice.
Hello, I will submit my appearance because the earlier counsel has changed.
Yes. I issue notice, file the process. Yes.
Much obliged.
Yes. Yes. Amount has already been deposited.
Yes, sir.
Is there any chance of settlement?
Yes, sir. Can you settle my lord? Today you are going to condone the delay.
Yes.
Mathematically, first week of March.
The reason creating the application, delay of told the Congo is the FAO for the hearing in first week. Yes. Next time settle the student come.
Yes, can we report?
Can we disclose?
Yes.
Delay of 48 days that will be condoned for the reason settling the application. So delay of 48 days to condone and FAO.
12 lakhs consolidated. 12 lakhs consolidated. 35 item, 35 minor. Let's display about
35. I don't know what. Huh? Huh?
Delay now, also judgment is there. I have brought that judgment.
Oh, that guy will out.
Dismissed by the. Non-apparent.
Non-apparent. Yes. Yes.
Okay, अन्य कौन सा राय मिलो?
10 days. I will be deposited.
First week of yeah. First week of March. Yes.
For my lord. My lord, there is a delay of response, my lord, that may be allowed, my lord. I have filed the petition for condonation of delay, including one
I
petition.
issue notice, madam. I issue notice. Huh?
My lord, and the IA for stay of the education case, because if the education case will finish, then this is influence, my lord. I filed the IA. That is 119 of 2025, my lord. Seda asini mo pachhare seda file korchi to seda asini lagini file.
Let it be listed then.
My lord, education case ए सप्ताह रोची. Mama number भी again रोची. खाली 119 of 2025.
Where is that award?
My lord,
Where is that order?
My lord, the order is annexure 1, my lord. Order is annexure 1. This is a peculiar order in which the learned court below stated that there should not be any injunction order. But in the order portion, he allowed the petition of the 47 section under section 47. My lord, kindly see.
Yes.
Keeping in mind the other questions to be taken. My lord, the page 10, my lord.
Page 18. What is this?
My lord. Page 18, my lord. My lord, kindly see whether the operative part of the decree in relation to permanent ejection is executable or not, and whether the execution is against any person having right, title, interest, and possession of.
That will be decided now.
My lord, this petition was, my lord, in the upper paragraph se कहले जे होची एगुडा किछि विचार करा हबो नाही बोलिका regarding determination of.
But what is the prejudice? Let it be decided in the.
No, my lord, in the execution case, my lord, the civil suit has already been dismissed, my lord. Thereafter, the appeal has already been dismissed. Then the civil suit is the order of the civil suit is binding on the parties, my lord. At that time, my lord, they have filed one petition to stay of the execution case, which is not, my lord, not proper, my lord.
So what you want now? What is the prayer in your application? Let us,
my lord.
So give me the application. What are you seeking here?
My lord.
ସକାଳେ ଫାଇଲ ହେଇଛି ସେୟା ପ୍ରୋବ୍ଲେମ
ଆଜ୍ଞା ହଁ ସେ ଏଜୁକେସନ କେ ସେଠି ମୁଁ ଭାବିଛି ରହିବି ଡେରି ହବ ବୋଲି ତ ମୁଁ ସେଥିପାଇଁକା ଆଜି କାଲି ପାର୍ଟି ଆସିକି କହିଲେ ନାଇଁ ଏଜୁକେସନ କେସ ସେ ଟାଇମ ଦଉନାହାନ୍ତି ତ disposal of FAO time.
Issue notice and the application for condonation of delay as well as the application for stay that is IA number 119/2025 which is stated to have been filed today. And the same application is has not come on record. In the meantime, release the matter in first week of first or second week this year. And in the meantime, petitioner is at liberty to move application before the trial court, taking in adjournment. If such application is moved, the same shall be considered of the court. You move an application. I have to give that.
My lord.
Yes. Yes.
This.
Yes.
This matter, the unfortunate party is a delay of 200 odd days. And the entire it's my mistake. I was on the surgery in the hospital. I lost sight of okay. I got it, the information I got on the 15th one, on the very day.
What are you seeking, by the way, in the petition? Yes, madam.
My lordship, I have not
Yes.
the copy.
Take the copy. He himself says that he was not.
Still, I have seen from the.
No, 3 years.
3 years.
Huh?
200 odd days.
200 odd days, but he himself got operated. We should have that. Have you written that those things in the applications? That. Show me that. Where is your application, sir? Yes.
Paragraph 3 years she finds. Here I have written. Back on the date of listing of the case, the counsel for the petitioner lost sight of the.
Acha, Mr. J. K. Das, he is willful negligence. Mr. J. K. Das was hospitalized. The indoor patient undergo surgery of completely complicated nature. All right. IA number 52 of 20. This application is filed for seeking condonation of delay for 700 days.
200 odd days. That's a doc.
Here you have written 728 days.
In 20, your lordship on 19/12/22.
Now let us see what 728 days, sir.
3 years.
19/12.
No. The SR report also says 728 days. In your application also you have said 728. It's not 200. I'll just issue notice. Issue notice, just check it up. And you file a better affidavit detailing your health condition and all. I'll condone delay, but you just give detail and some document. Okay. I'll simply issue notice. The counsel for the petition seeks to file additional affidavit to explain the delay caused in filing the CMA. Yeah. You just I'm fixing. Fix a date. Huh? Yes. File a affidavit also.
Yes.
Supply the copy. Let us see.
46.
May I please, Your Lordship? My Lordship, my senior is out of state, so kindly list this matter after 2 weeks.
The request.
Lords, may I kindly say I am appearing for the opposite partner of 2, my lord. There are 138 NI 143 A ki order hitla, and challenging that order, this petitioner came up before your lordship, and
Madam, there is an interim order in
Yes.
138 matter.
Yes, my Lordship, but I have no power. So my senior is absent.
That's right. You have taken the interim order when you know.
My lord,
22.
my lord.
2022. 138 matter is stuck because of this.
Yes, my Lordship.
That's the problem. What is the matter is about?
Matter in the amount of involved, my lord, 4 crores, my lord. 4 crores
What are the
91.
grounds? Why the court decided to give stay?
Only because, my lord, they have taken a ground that, my lords, they have appeared and
Interim compensation amount.
interim compensation.
Against interim compensation, you came and main complaint is stay.
Yes, my Lordship.
Tomorrow.
Okay, my Lordship. Obliged.
Huh?
Tomorrow.
Day after tomorrow.
Day after tomorrow.
Madam, day after tomorrow. See, I'll vacate this stay. What is this?
47.
Offense under 498A and 325, my lordship. And there is a compromise petition also. but
Nobody is here.
not-
I'll pass it over. Make it. Yes.
48. My lord, kindly see, my lord, order dated 19/3/24.
19? Okay. Yes. Yes.
Now,
It's the recovery case.
your lordship, may kindly recovery money, your lordship may see how the complaint is filed and then we entertain. Your lordship may kindly come to annex to page 16.
No, but who is appearing? Have you served?
Senior.
Yes, sir.
I'm appearing, my
What
lord.
is-
With all humility, I can say, indefensible, if I can say. If your lordship
Sit
can-
together and finish it up. Why?
How to sit together?
If
Is the complaint maintained?
No, that apart. Now fact remains that some money has to be paid.
But money.
The complainant has to go. I know that. Complainant has to go and he also knows this.
See, who are the officials there? They are roped in Tata officials. Your lordship may kindly see.
I have stayed the proceeding.
Yes, sir.
And
What
what is the amount you tell me, Mr. Mishra will tell? What
1
is it?
crore 65 lakhs.
Have you filed any recovery proceeding?
No. Thoroughly wrong
Means
legal,
completely misguided.
wrong legal advice.
Completely wrong.
So if
How will you maintain this complaint?
I bow down, my lord, I have no answer to that. I cannot.
He has every type of.
But at the same time, you have to pay something there. Why don't you pay?
But is this the way of?
Shall I send it to mediation?
Not that is, a regional officer is here, they are at Bhubaneswar. Let him sit with my client if something can be sorted out in the mediation sense.
He can very well go to the forum for recovery of money.
Oh, that is.
Now, the limit, but the limitation will come in.
She is a lady, she does not have to pay any fee.
But limitation, when was it due?
But when he could not do in other way, he wants to do in this.
So 3-year limitation has gone. So he had no option. He had to employ this method to,
But lady would have filed for her.
Let it go for a mediation, let the mediation. fail.
Try. If it doesn't happen,
Yes.
then I'll have to quash it.
So,
I'll see. You explore the possibility if something happens, I have stayed, I'll have to quash it. I'll have to quash it. But don't keep that in mind.
No,
So
no,
that
Yes. Whatever falls from.
no, he says that this is not maintainable. What else you need?
Whatever falls from your lordship mouth, unless it is there in black and white, it is not an order.
But it's all right. But he also knows that this
Yes.
complaint is not maintainable. He says that. So therefore, it can be, sent to mediation for just have a try.
Government.
High Court Mediation Center.
No, let it be in Bhubaneswar because all the parties are in Bhubaneswar.
Okay, Bhubaneswar District Court Mediation Center. Tell you to explore possibility of settlement, awaiting mediation report. Please see matter and also entry order to continue.
But one thing.
Yes.
With your lordship's time for. But the mediator may give individual notice to both the parties because
he will fix a date and intimate to the party. Yes.
Parties to directly because
Yes.
we are both my senior and we are here. We cannot run.
Yes.
Local
That order will pass. Yes.
49.
Whatever he is giving you, take it.
Yes, my lord. That also. I have
Don't expect
I have
that. Whatever little you can recover it. Otherwise, neither you are here nor there. Even section 14 benefit also you can't get because this is not a proceeding. Bar is bar.
It's a statutory bar.
So you can't help it. So therefore, neither 37 nor 34, nothing can be filed. Whatever you are getting, take it. Yes. That's the best thing. Yes. 14? 14.
May I please, Lord? My lord, petitioner want to surrender, so kindly extension the time for surrender.
Sorry?
Extension for time to surrender.
Extension of time.
Yes, my lord.
You deposit the 5 cost?
Yes, my lord.
Time extension could be okay, allowed. No further extensions. Yes.
50.
This matter was referred for mediation, but mediation we, in spite of our appearance, opposite party one did not appear, did not come, my lord. So this is the allegation of the only the against the protest petition by the opposite party number one. The cognizance has been taken, although there is no nexus. He is not a matrimonial member, the petitioner. So now,
who is appearing for opposite party?
Opposite party, but he did not come in spite of the notice. It has been
by docket dated 3/10/2024, the matter was referred to mediation, High Court Mediation Center. High Court Mediation Center. The mediation appears to have been unsuccessful. Therefore, a report dated 11/2/2025 is placed on record. Release the matter for final disposal. Interim order to continue. None appears for opposite party number 2. Yes.
Interim order, my lord.
Interim order to continue.
This will come, my lord. This
He'll give a date. Yes.
Wait, please, your lordship.
Yes, sir.
Lordship, in the last order, notice was issued to the opposite party, my lord.
That is sufficient.
Yes, my lord. My lord, this is a case of violation of Ernest Kumar judgment, which has already been duly recorded by a learned magistrate. My lord, kindly have a glance, page 18.
Nobody is appearing for opposite party. Despite
Yes,
that, none appears for opposite party number 2. Leaves in the interest of justice, leaves the matter on Saturday. Interim order pass on 3/12/2024 shall continue. Yes.
Fair career भी नहीं, my lord. Say,
let us good take opportunity देवा पड़ियो ना. Service page.
My lord, a short date.
Short date. First week will yes.
May I plead your lordship? Item
Yes.
52 IAS file 298 of 2025 for extension of surrender period as well as modification of the lordship order. On 9/1/2025, order was passed in para 2 that the liberty given to surrender before the court below on or before 25 January 2025. But lordship, here the very offences is under section 366 and 368, which was triable by the Court of Session. Lordship, I pray that if the court below rejected my bail application, I may move bail application before the session on the same day, first or second.
So you have not surrendered so far.
Not sure.
You,
No, Lordship.
you seek extension of time.
Extension of time, and as the offences are triable by session and the order was passed by the before the court below, surrender before the court below, I pray if the court below rejected my bail application, I can move the bail application before the session on the same day, first or second.
9/1/2025, the this court, while dismissing the CRLMC, directed the petitioner to appear or surrender before the court below on or before 25/1/2025 and resort to the remedy available to him under law. By way of this application, petitioner is seeking extension of time to appear before the court, appear or surrender before the court. Regarding head to the government filing application, the time is extended till 15th of March 2025. 2025, and the petition is directed to appear surrender before the court on or before 15th of March 2025 and resort to the remedy available to him under law after the appearing or only surrendering before the court. If the petitioner moves application for breaking if plea fail, the same shall be considered by the courts below, rural courts below, in accordance with law on the same day. With this observation, the petition is disposed of. It is made clear that no further extension can be granted to the petition. Yes, next.
Lordship, I am for the petitioner. Lordship, my sincere apology. As in last occasion, Lordship have directed to file a requisite in 3 days. Due to miscommunication, the advocate has not filed. Lordship, my humble prayer, just allow me 3 days to file the requisites, Lordship.
Okay, give 500, huh? Mediation also failed.
Mediation, we have in every hearing, the petitioner has attended the mediation.
Flag B, that is BSNS report is flag B.
Okay, the requisites have not been filed to serve opposite, but the opposite party in the
she was present.
The requisite was not required in that. Requisite is not filed to serve opposite party number 2. He undertakes to file within a day, within 2 days.
2 days.
Within 2 days, huh? Fine. Okay. Release the matter on short. Yes.
54. Obliged.
The extent of time to surrender, my lord. Extension of time for the reasons stated in the application, the same is allowed. Extended to 15th of March. No further extension. Yes.
55. What is lordship, as per lordship direction, my lord, I already added the informant as a party.
Yes. Yes. What is this matter?
My lord, that is one quashing of the criminal proceeding. I am challenging, my lord, the annexure 2.
You are appealing for the opposite.
I am appealing for the informant.
Yes.
And here the challenging, my lord, the order of the, my lord, annexure 2, page 15, my lord, 18/9/20. Here, my lord, the offense, my lord, 376 2FN. The FIR, my lord, filed, my lord, 5 years after the occurrence. And at that time, the age of the victim was, my lord, 38 years. But the petitioner age, my lord, 40 years, my lord. The allegation, my lord, that 5 years back she was working under a grocer. Where the petitioner, my lord, working as a supervisor in that, my lord's factory. And the day of the occurrence, my lord, he forcibly committed rape. Thereafter, subsequently, my lord, he, with assurance to marriage, my lord, kept physical relationship. Subsequently, their, my lord, avoiding for marriage.
Yes, is there any scope of settlement?
Yes, Milos. I have instruction that there can be amicable settlement between the parties.
Settlement come, my lord. Entered appearance on behalf of opposite party and entered filed Karatnama taken on record regarding head to the nature of allegation made by the complainant against the petitioner. Against the petitioner, the learned counsel for the opposite party, the learned counsels appearing for the party submit that there is scope of amicable settlement between the party. Hence, seeks an adjournment. Release the matter on short. Yes.
Affidavit also will not file, that is.
To do whatever 376 years. Thanks. করো 15 দিন পরে।
58.
Service. Service complete. Who is it?
I am the opposite party.
Kind of look at the sequence of dates is challenging
You
the
are ready?
comprehension.
Ready?
Your Lordship.
Ready?
Your Lordship.
Yes.
Petition number 1 is the mother-in-law, kindly see, the complainant. Opposite party number 3 is the husband. OP number the son of the petition number 1, and OP number and opposite party number 3. OP number 2 is the complainant. The petitioner for quashing of the order of cognizance dated 20th May 2017, part of the JMC Bastain City case so-and-so, on section 498A, 406, 506, 34 IPC. On 22/1/2013, marriage was held between OP number 3 and OP number 2. 2015, a male child was born. Allegation that husband kept illicit relationship with other women and problem. On 15/11/15, wife left the matrimonial home. 1cc case was registered before the SDJM Baleswar for alleged offense on section so-and-so section. Then 15/3/16, FIR was lodged based on complaint petition under section 156(3) of CRPC. 17/5/17, charge sheet was filed. 20th May 2017, cognizance was taken. 2018, a joint compromise petition was.
Show me the compromise petition.
Kindly have a look at it, page 44, my lord.
44. Yes. Now, lot of disputes. What do you say? You have to
Mother-in-law has been unnecessarily harassed, in fact.
No, in this case, my lord, it is a
you decided to keep on fighting throughout your life.
No, man.
There is a child.
Your Lordship.
Conjugal right, you have compromised.
Your Lordship.
And still you are going ahead.
No, my lord.
And
We have
maintenance is being paid.
numbers of cases, my lord. In my.
Will you settle it? I'll send it to mediation, settle it. and
I
come.
am ready to settlement, but they.
I'll stay the proceeding and go and settle it.
When
These
they-
are matrimonial disputes.
Yes,
There is a
yes.
child and you are getting maintenance. And he files a restitution of conjugal right. You go and settle there. And thereafter wriggle out and.
After settlement, we reject there. But they file a case against me that I am in a theft case, in another case. Number of cases filed by.
The fact remains it is a matrimonial dispute.
Yes, yes.
You can.
Until-
The senior counsel has pointed out the sequence of event that has unfolded in the present case and submits that the parties can to the mediation, High Court Mediation Center to explore a possibility of settlement.
Already
to
there
which-
might be.
To which land counsel for the petitioner also agree. And in view thereof, the parties are relegated to High Court Mediation Center, coordinator to take the date and intimate. And in the meantime, proceeding before so and so state, awaiting mediation report, please there. Yes.
Already mediation there. Can you see page 57 in the High Court Mediation Center?
Huh.
Can you see page
See,
57?
mediation, you can keep on doing mediation, you never know what happens. Within second, mediation happen, second it is broken. So even if it once it is done, once again you can try.
So question,
It's matrimonial.
mother-in-law is being harassed, my lord.
It's
They-
matrimonial.
Main allegation against them. The husband, a lot.
Go and try.
A lot.
If it doesn't happen, then on merit you will see whatever.
I am given out of court also give an option in the lower court, but they have not turned up. They file
But
number of
now,
cases.
now he, see, he is
Mother-in-law
appearing and
says-
saying it
agree.
makes a difference.
A lot.
Now a senior counsel of his stature is saying,
A lot.
then
If you ready.
lot of difference. Lot of difference. You now you try if
Yeah.
I think it happens.
But the interim order is there.
Entry mode to continue.
Right.
Yes.
Problem. Denied.
Petitioner Miller filed this application challenging the order of cognizance dated 28/2022 on the ground that the allegation made in the FIR not prima facie established.
Yes.
In the FIR Miller, lodged on 27/7/18 Miller on sections 365, 373, 307 and 120B IPC Miller. But in charge sheet file after
370,
Miller?
376 also.
No, 376 no, 370. 370. But in charge sheet file, my lord,
Hmm.
total no offense of FIR in the charge sheet available. Total different of offense. 466, 460, and 511, my lord.
Hmm.
After 4 years, my lord. Yes, it's like this, my lord. A surprise race conducted in my clinic, my lord. On allegation, my lord, procurement of infant child, my lord. Subsequently, it was found the two infant child is there, my lord. And page 25, my lord, one mother of the infant category stated, my lord, due to temporary period, my lord, Mamina Bhoi, for temporary period, I have kept the infant in your clinic because in the clinic my sister was working as a nurse, my lord. Subsequently, that was happened, my lord. And
Regarding one child, the other child?
a male child. After DNA test, that was handed over to him, to her, my lord. Under Annex 5, page 28.
Yes.
DNA test both are same. Then second child, my lord. Second child, my lord. One Kavita Rao is a mother. Yes, that is stated, my lord. He was unwanted mother, my lord. His life was in danger. That's why he came to clinic, my lord, for abortion, but it was more than 7 months. Not possible, my lord. That was childbirth, female childbirth birth, me. Then, my lord, subsequently, my lord, one person came, my lord, was already one FIR against him, had already been set aside, my lord. That is Pooja Soren. I am on a similar footing. He wants she lady with a issueless. He wants to adopt that lady, that baby, my lord. Subsequently, his name was recorded in the birth certificate given by the municipality.
How can you do that?
Already recorded, my lord.
How that can be done?
On that ground, my lord.
Mother is someone else.
Yes, because she does not
And
want to
somebody else will come and say that my name.
Unwanted
marriage. Who is the Pooja?
Yes, he's a issueless lady, my lord. He
She
wants
say
to
that you record the child as I am the mother.
kindly come to my lord. Page 25, page 26, my lord.
All these things.
ମୋ ନା କବିତା ରାଉତ ଆଜି 25 ସକାଳେ ମୋର ଯନ୍ତ୍ରଣା ଅସହ୍ୟ ହେବାରୁ ମୋ ବାପା ମାଙ୍କୁ ଜଣେଇ ସେଦିନ ବାପା ମତେ ସାଙ୍ଗରେ ଧରି ଜଗତସିଂହପୁର ମେଡିକାଲରେ ଗଲେ। ସେଠାରେ ଉପସ୍ଥିତ ଥିବା ଆଚାର୍ଯ୍ୟ ସାର୍ ମତେ 7 ମାସର ଗର୍ଭବତୀ ଜଣେଇଲେ। ମୁଁ ଗର୍ଭବତୀ ବାପା ଜାଣିବା ପରେ ମତେ ଯେମିତି ହେଲେ ଉଦ୍ଧାର କରିବା ଡାକ୍ତରଙ୍କୁ ଅନୁରୋଧ କଲି। ଡାକ୍ତର ସାର୍ ମତେ ଡେଲିଭରି କରାଇଲେ। ଗୋଟିଏ କନ୍ୟା ହୋଇଥିଲା। ଉକ୍ତ ଶିଶୁ କନ୍ୟା ଓଜନ ମାତ୍ର 1 କିଲୋଗ୍ରାମ ଥିଲା। ମୁଁ ଅଭିଜ୍ଞତା ହୋଇଥିବାରୁ ଛୁଆକୁ ସାଙ୍ଗରେ ନେଇକି ଗାଁରେ ବଦନାମ ହେବାର ଆଶଙ୍କାରେ ଗାଁକୁ ଗଲେ ନାହିଁ। ମୋ ଦେହ ଭୀଷଣ ଖରାପ ହେବାରୁ 20/6/18 ତାରିଖ ଯାଏ ସେ କ୍ଲିନିକରେ ରହିଲି। ମୋ ବାପା ମା ମୋର ସହମତିରେ ଶିଶୁ କନ୍ୟାକୁ ଡକ୍ଟର ଆଚାର୍ଯ୍ୟ ଜୀବନ ରକ୍ଷା କରି କଟକରେ ପ୍ରାଇଭେଟ କ୍ଲିନିକକୁ ଗଲେ। ସେଠାରେ କ୍ଲିନିକକୁ ରଖିଲେ ଏବଂ ମୁଁ ଶୁଣିଲି 36/7/18 ଶିଶୁ ମଙ୍ଗଳ କମିଟି ଅଧିକାରୀ ମୁଁ ନେଇଯାଇଛନ୍ତି ପିଲାକୁ। This is the Kavita Rao statement. Which subsequently, my lord, this Pooja Soren, my lord, he want to adopt that baby, my lord. He has already allegation against him already set aside.
But
I have already given
that document is already on record. Said Pooja Soren is in different footing, Your Lordship. He is the receiver of the male child, Your Lordship.
Male,
on the
female
instance of
child.
the present petitioner, Lordship.
Yes, female child,
Present
not male
petitioner has already taken 80,000 from herself, Your Lordship.
Yes.
You have taken money also.
No, not taken money, my lord. He has categorically stated, my lord.
What kind of document you are?
No, not taken money, my lord.
Yes.
Because, my lord, post
80,000 is taken.
No, not money.
Yes, that is there.
No, not taken, my lord. Not taken money, my lord. I have received money for the nourishment of the child, my lord. That is because the child was below 1 kg weight at the time of delivery, my lord. For save his life.
Show me where
Yes,
he has taken money for.
Yes, Aravinda Khuntia mote more syndicate bank account so and so that dated 28/5/2018 le 50,000 टंका वो ता 4/6/2018 ले 30,000 टंका एक 50,000 बैंक अकाउंट so and so को पठाई थिले
कागो पठाई थिले
ए प्रेजेंट petitioners
डॉक्टर पद्मनाभ
yes Dr. Paramanand Acharya yes that is there.
Who is he?
That is the yes, that is the Your Lordship.
Who is he?
Yes, Your Lordship. Aravinda Khuntia, Lordship.
Who is that Khuntia?
Aravinda Khuntia is one of the well-wisher of the present petitioner, Lordship, who is close to the present petitioner. He regularly comes to the nursing home of the present petitioner, and as per the Khuntia, that lady has taken that minor child.
That Pooja.
Yes.
And Puja paid 8,000 to that Khuntia.
Petitioner.
Khuntia transport to him.
Yes, my lord. That is that. My lord. Then, my lord, that lady, my lord, not giving money for the post-delivery complication, my lord. To save the life of the baby, my lord.
But how will you know all these things?
Save the life of the baby, my lord.
Now, how will you know all these things? Unless you are put to trial, how will you know?
Can I have a glance, my lord?
See, this judgment,
Puja was given money, my lord. His proceeding has been set aside against him, my
have you
lord.
seen it? Puja.
I already given.
That is different putting.
How different putting?
Totally different, your lordship. It is not covered in the present petition.
No, just examine one thing.
Yes, I will.
She was a co-accused.
Yes.
What exactly has happened is this Puja Soren has taken the baby
Yes.
by paying money to this doctor.
Yes.
And the child was born from another minor girl. Oh, that is a illegitimate child.
That's
They
right.
want to get rid of that child.
Yes.
So this man encashed the situation and given it to Puja by taking money. Now Puja come to this court and his FIR is quashed. So what will happen now? See, just what will be the consequence if he is put to trial in the absence of Puja? The entire chain of event goes.
My lord.
So what will be the impact thereon? Have you challenged this order?
Not
I
challenge.
have no instruction for the time.
See,
your
the
lordship.
chain of event goes. So therefore, subjecting him to trial may be a futile exercise. Therefore, he is saying that
In
that way you have to examine it.
In Puja Soren case, there are 3 petitions are there. Only in respect of Puja Soren, the case has been quashed. Remain is the Khuntia S. Aravind Khuntia and S. Chandan, that they are this coordinate on another coordinate bench, not inclined to.
Where is that? Where is that?
That is in judgment in the lordship page 2. And says this lordship's judgment of page 2 your lordship.
Get that order.
Aravind Khuntia and
another thing, my lord.
the second page, Aravind Khuntia and S. Chandar, including the present petitioner, had filed this application, but the same was not praised in relation to Aravind Khuntia and S. Chandar.
Then Aravind Khuntia and
S.
facing.
So and so also present petitioner also.
My son, my lord. Allegation made in FIR, not in charge sheet.
Why have you not pressed for Aravind Khuntia and all who is instrumental in getting the money from Soren? Soren is a poor lady. She is a issueless mother. Rather, she has paid money and taken a child who was abandoned.
And look, now.
So then he has done a good service
Now,
you are encasing the situation. Poor motherless lady and a girl who was unfortunately got pregnant. This thing, and these 2 women. You have exploited the position.
No,
your position as a doctor.
My lord.
That's the long run. Today I am not with you.
And
today I am not with you. If you want, I will write a judgment now.
Doctor is more than 80 years old, my lord.
The poor lady, see, the Puja Soren is also just she. She is a issueless woman. He wanted a baby.
Let him say words about that baby, my lord. Now baby is where, my lord? They have taken the baby, my lord. Now where is the baby?
Baby must be there with
No, baby with them, my lord.
Baby has been taken by
That part I will verify.
Let me say, my lord, where is the baby, my lord?
Then it is injustice to this lady also.
Yes, where is the baby, my lord?
That part I will.
Let him say, file an affidavit, where is the baby, my lord? That order may pass, my lord.
No. I will not start an inquiry. Parallel here. No.
Say again, baby, tag nahi kuwa.
Is that the scope of this petition? Your case is made out on.
Sir, neleni portal baby ro where sabod nahi.
We'll see.
Ame dekhin baby biki del na kon korchen kooti rakhila ke.
That is none of your business.
Yes, that is correct.
None of your business. The fact of the matter is you have exploited the situation.
Question doesn't arise.
The girl who
I have served, my lord.
No. What serve? Taking money 80,000 rupees serve?
Not for me, my lord. Talking about not for betterment of the child, my lord. I have in the ICU, my lord, in the Kotak, my lord.
That's one side of the story. If you have not taken money, you have done it, then it's really a service. But you
I have taken my fees, my lord.
Then what service you have done?
Fees to nahi chahiye कौन है क्या doctor
to see that. Okay, continue.
Item 62, your lordship, we are informally trying to settle the matter. Kindly the matter be taken up on some other days.
62?
Yes, your lordship.
Who is appearing for opposite side? Yes. there is a joint request for adjournment for this matter on the ground that the parties are exploring the possibility of out of court settlement. Please the matter. Yes.
Yeah, there, it was there. Item 53.
53, yeah.
Obliged.
53 interim protection was there to continue.
Obliged.
To pass over after pass over. Yes.
Item 10.
May I please?
1 minute. Yes. Yes.
Present petitioner and the opposite party number 2 met. Was in a relationship since 2015, 16 met. And lot of transaction of money transaction is there, madam. After that, there is a breakup. And after in 2023, he has lost the affair against me that I have kept physical relations and charge sheet submitted under section 376.
Yes.
Your lordship, if your lordship go to the affair manner, it is a very lengthy affair manner. But your lordship can't have page 80.
She might have narrated the lengthy
No,
incident.
lengthy incident se ଟଙ୍କା 5 ଟଙ୍କା ନେଲା 15 ଟଙ୍କା ଫେରେଇଲା ଏମିତି ଚାଲିଛି ଏଇଗୁଡ଼ା ସବୁ ଲେଖିଛୁ କିନ୍ତୁ ସେ ଲେଖିଛନ୍ତି 80 page 80 ରେ ଖାଲି ମୁଁ ଯାଉଛି now in near future I came to Odisha at his CDF flat April.
Where are you reading?
Well, page 80. 80. 1,
Yes.
2, 3, 4, 5,
Yes.
6, 7. 7 from the bottom. Now, your lordship got it. Got it well.
Yes.
Now, in near future,
future,
I came to Odisha at his CDA flat on 14th April to settle this case. So I pray she wants to settle. I also want to settle.
Settle.
So your lordship may issue notice.
No, I'll issue notice. In any case, I would have issued notice because these are. Have you implemented this notice to the informant victim to be served in process, ordinary process, as well as through the IIC, as well as through the IIC.
I have filed NBW.
NBW has been issued or stay the NBW.
I number 178.
Petitioner earlier approached the Honorable Court and a bill
finish.
In that celebration, that this Honorable Court has passed an order. That order has not been complied with.
What is the order? They will surrender.
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 That order has been extended by
See, the fact remains that there is a chance of settlement, and the relationship was going on for years.
But here, the present petitioner, by actually already married man, by giving false assurance of marriage, committed sexual intercourse, obtained financial benefit from.
She is not a minor. She should have known about all these things before entering into such relationship. And this is not a one isolated incident. It is going on and on for a longer time. So, and money exchange, both the side, she pays to her and he pays to her. All these things, they were in deep relationship. Somehow it has gone wrong. Whatever. For the execution of NBW issued by the which court?
SDGM Kotak.
SDGM Kotak. By the order dated?
I had order dated, my lord. 23/11/2023.
Is state till next date appeal. Yes. And come out with proposal and settle it. Yes.
Well, I have filed my appearance.
Mr. Tripathi appearance. Yes.
31.
21, huh?
31.
31. Okay, 31. Right. None appears for the petitioner even in the second call. This matter is pending since 2003. Yeah. This review petition is pending since 2003. Is there any Objection? The even in order against which the review petition has been filed has not been filed, and the SR has pointed out the defects. Despite that, the defects has not been cured. In view thereof, it appears that the petitioner is not interested to prosecute the matter, hence the same is dismissed. Yes.
47.
Yes. Yes, madam. This is the problem. They say we have settled the dispute, take a stay, thereafter don't come. You are appearing, madam? Yes. You say that you have settled the dispute. I granted stay. Thereafter you are seeking time and stay is extended. Whatever, madam, whatever, I don't know. You said that this matter is settled.
Yes.
They should be here. That's all.
Yes, next week.
Next week, why? Then I need vacate interim order. You come at your pleasure. What to do? See how many hearings? 3-4 hearings you have taken.
Yes.
If I think they have not settled. Only for getting a stay, you might have said that.
He's doing job. She could not able to leave.
Yes, madam. Yes. Matrimonial dispute. What to do? 498 and by last notice. Okay, interim order. Bring them and finish it up online. Let them appear online.
Yes.
They may not come. They can appear. I will fix the time also. 2 o'clock. They should come and appear and finish it up. Take. Special notice, no? Yes.
Lord, this is a petition under section 482 seeking quashing of affair relates to the wife of the public servant. In the first round of litigation, this honorable court disposed of with a direction to the petitioner to file all its income tax return before the IU.
Yes.
It was complied with by in 2021. Thereafter, the IO neither has filed the charge sheet nor given a clean sheet to us. My lord, in the recently
FIR is 2020.
to 2020.
20. Against your husband as well as you.
Yes, my lord.
13.2 and 13.2B.
Yes, 13. My lord, one thing is also important. My lord, just turn to page 17. That is the check period. And this is a case, my lord, where the entire service period has been. That is at page 17, my lord, just third paragraph. The entire service period of SO from 24 February 1986 till the date of house search, that is on 12th August 2020 has been.
That's good for you. At least you can.
No, my lord, that's
larger period.
Yes, my lord, that is what, my lord. Now I am.
Vigilance case, na?
Yes, my
lord. Who is appearing for vigilance?
This is a.
Sir, see, there is an order passed by the coordinate bench giving liberty to him to place all the material before the IO to take into consideration. This order was passed way back in 2021, 29/10 to 2021. Thereafter, the charge sheet has not yet been filed. Therefore,
I'll take instruction that whether in the meantime.
But what is this?
My lord, in the similar cases, my lord, just turn to page paragraph 8.
8.
Yes.
Yes.
The appellant has declared his and his wife's assets consequent to notice dated 25th August 2020. It is stated that the wife of the appellant is also earning from teaching yoga, agriculture, and from receiving house rent. It is submitted that the appellant's total income since 1996 to 2020 is rupees 75,73,676, and the income of his wife during the aforesaid period is about 41 lakhs. These declarations are supported by the relevant income tax returns. The ornament of the appellant's wife have been sold for an amount of 22,16,000. And
this is again fact. What is the law?
What they have then para 9. we are of the view that the appellant's wife's income must be considered as well.
That is why the coordinate bench has
Yes,
passed the
ma'am,
order.
yes, ma'am.
Let them consider. That is the reason. Rightly
that-
passed. The coordinate bench has
Yes.
rightly passed this
Yes,
order.
ma'am. Yes, ma'am.
And whatever income tax, whatever you have, you give it to the IO. You have given.
We have,
agreement to you. And let it be.
Whether in the meantime or not, so whether investigation completed or not, I'll just.
That's the precise grievance.
I'll
The coordinate bench says that income tax, whatever she will be giving it to you and you take into consideration. And whether you have taken into consideration or not, nobody knows.
I'll come back to your lordship, my lord. So whether in the
Please
meantime the
notice, Mr. Das
investigation.
accepts notice and submits that
The status of the investigation.
He would be seeking instruction regarding the status of the
Investigation.
status of the investigation. তার উপরে লিখে দেব। তারপর লিখে Mr. Patra and counsel for the petitioner submits that on 29/10/2021, the coordinator bench of this court, while allowing the CRLMC number 1540 of 2021, has directed the petitioner to submit all the relevant papers to the IO, and the IO is directed to take into consideration the same in accordance with law while dealing with those documents at the time of filing of the charge sheet, publicly the final form. However, the charge sheet or public filing form has not yet been filed. He is relying upon the observation of the coordinate bench made para 4, page 31, para 4, page 31. তারপর দেখিও Mr. Das, Mr. Das submission, least the matter concerns with the second week.
May I request my lordship, lords, to give a spare copy of the petition and also the judgment copy, lords.
Mr. Patra undertakes to supply the
Right now, I'm
spare copy of
I am handing over
The application, my lords, that is in hand of Mr. Maharana, lords.
entire petition.
That will help me to send the
and
latest, my lords.
Entire
Oh,
petition and
thank you,
relata
thank you,
petition.
sir. Good enough, good enough.
No, my lord, I have already handed over.
No, this is the judgment. The petition.
The petition.
Petition copy, my lord.
Along with the
Along with the annexure and also the.
portion কাটি দিন।
Grateful.
Yes.
Problem.
Yes.
61.
61.
My lord, date, returnable date.
Second week. He has to seek instruction.
I don't know if date can be fixed, then it will-
Date will be fixed. Don't worry.
Lords, usually I don't expect any orders copy. It may be expedited, but so far downloading the copies, well, I'll get the copy.
Yes, yes. Second week.
Because his
upload করতে হবে। Upload আছে।
So that his submission has been recorded, my lords. That will give the momentum, my lords, so the investigation.
May I please?
Thank you, Mr. Das, who is present in the court, is accepting the notice. Present in the court,
A copy was also served in court.
and copy of the petition along with the relied upon judgment has been supplied to him.
And he may be provided with the copy of the order also to get instruction.
Supplied to him. Copy of the order supplied to him. Yes. Free copy of the order be supplied. Yes.
May I please? Last occasion, lordship has issued notice to the opposite bat number
Yes,
2. And he has already been appeared, madam.
So he is appealing. Okay,
I'm appealing for opposite party.
Yes.
Ma'am, but in this case, FR was lost for registration of a land. Subsequently, it is came to knowledge that that land was sold before that, madam. This is the allegation. The entire allegation against the father of the petitioner, madam. That amount he has been taken, the agreement he has been signed. The petitioner being the obedient daughter of the her father, only signed the sell deed, being the legal, being a co-sharer of the.
Then who knows? 120p is also there. You never know.
But is there any?
You have taken money from someone.
By the time when the registration was made, he was a minor, 17 years some days,
Yes.
And so far as the allegation is.
How much you had taken?
My lord?
How much you had taken? Your father?
Father, as per allegation, 4,20,000.
So pay it.
By that 1,50,000. My case is that let trial be made against his father.
No.
But the petitioner is a 18 years girl.
You have signed the document, and the document is alleged to be false document.
No, documents not for what?
But you have cheated in the sense that the land was already sold
What is
earlier.
what is the case, my lord? The land actually belongs to the deceased mother of the petitioner. After her death, the land was muted in the name of the present petitioner and her father, being the legal heir of the mother, my lord. The land was muted. They have no knowledge.
Yes, 1 minute. Yes, Mr. Mishra.
Lordship, just give me 1 minute.
How much you have paid, you tell me.
Sir, 1,50,000 they paid us. But as per the Bhuleka, the property belongs to the present petitioner's name. Tushar Kanti Praharaj and Silpra Praharaj. They both are the owner of the said property. And there was, as per the story of the petitioner that the petitioner was minor. But I have annexed 3 on my counter reply, Lordship. There was a declaration took place in the PS where the petitioner, the present petitioner put her signature on the declaration that they will pay the rest amount within 7 days. The present petitioner father is a practicing lawyer's, Lordship.
I'm sending to mediation, settle it, pay it. Just 420, 468 and all. You will be in trouble. Pay the money, you have taken the money. Why unnecessary?
Father has taken it, not. Anyway, Lordship may send it.
I will send it to Sambalpur District Mediation Center.
Not Sambalpur, here, Kottama, because after that.
No, FIR is in Sambalpur. But you don't want to pay the money, but you don't want to pay. And you can afford to stay away from Sambalpur. You pay the money, finish it up. You have taken, the fact of the matter is you have taken for selling a piece of land. And you have not given the land. As simple as that.
I am the daughter, my lord.
Daughter of all these things. Your father has taken the father should have returned the money.
This daughter is continuing her study. He has no fault.
But I think you should pay it.
Lordship may consider that being the obedient.
Otherwise, there are allegations. I can't quash it. Then unnecessary. The
161 statement, whatever is that allegation is against the father. He has taken the money.
Sir, I can't today at this stage. I can't analyze the 161 statement and record a acquittal in your paper. The fact remains that you have taken the money. Your father has taken the money. You have signed the documents. That's the long and short of the matter. Then you have to subject to be those things has to be tasted in the trial.
Let it go to the.
I will just send it to mediation. Pay back the money with installment, whatever. He is interested in his money.
Your only daughter is the petitioner, no father.
Whatever. Right on. Regard being held to the nature of allegation made against the petitioner. I am up for the cultured review that the matter could be explored for settlement, out of court settlement. Learned counsel for the parties appearing in the court have also conjointly states that they will try for settling the matter through mediation. And Sambalpur mediation.
They're appending of.
Sambalpur you appear through VC also. Appear through VC.
They are appending matter. Otherwise, the middle place and you have matter.
No. FIR is there. IO would be there and all. The matter is sent to Sambalpur Mediation Center. Sambalpur District Mediation Center, reporting officers to issue notice to all concerned related to the case and explore the possibility of settlement and file a report before this court by next date of hearing. 3 weeks for the weeks for. Yes.
Protection may be given no rights.
Nothing will happen in the meantime. No course of action shall be taken against the present petition. Okay. Yes. She's a girl, na? She's a girl.
That is why I am updating for Sambalpur matter.
Young girl, unnecessary. Father might have done something. Why unnecessary? No course of action against it. Yes.
63. I am for the opposite party.
Yes.
I am for the opposite party.
Yes. Who is for petitioner? What happened? Mediation?
Mediation report is there, your lordship.
Unsuccessful. Mediation is unsuccessful. Non-appeals for the petitioner, shown to enter appeals, appeal for opposite party number 2. In the interest of justice, please the matter. There is no say, nothing. Let it be here.
Suppose the Lordship kindly have a glance to the order dated 22/4/2020.
Yes.
Whereafter I flow my person.
Appeal for the police in the check. My client yeah. Yes.
My Lord, may kindly turn to page 10 for a moment.
There is some typo in the order. Page 10, huh?
Yes. My Lord, may kindly see who is the complainant in this. The complainant is Shri Pradeep Kumar Das, son of such and such, authorized representative of Mega Fuel such and such.
Yes.
Now, your Lordship, may kindly see the averment at paragraph Roman 2 at page 11.
Yes.
That the wife of the complainant, Srimati Sujata Shaw, wife of Pradeep Kumar Das, is the proprietor of Mega Fuels on and such and such, and
These will selling and so on. So, yes.
well, the affidavit which has been filed by the complaint petition has placed 38 by the wife of the complainant. The wife of the complainant, husband. The wife of the complainant, Sujata Shah, is the proprietor of such and such, and the complainant is authorized, representative to look after the said business. Now, your Lordship may kindly see the evidence. Page 14. This is the evidence on affidavit.
Yes.
Paragraph 2, page 14. That the wife of the deponent, Srimati Sujata Shaw, wife of Pradeep Kumar Das, is proprietor of Mega Fuels such and such. Then, your Lordship may kindly turn to the notice at page 22. This is a legal notice given after the bouncing of the check. Page 22.
Yes.
That the wife of my client, Sujata Shaw, is the proprietress of Mega Fuels and outlet petrol pump, and such and such, and the
Yes.
Pradeep Kumar Das.
What is your
Yes.
case?
Then you Lordship, then after I do. Paragraph page 23, that my client deposited this said check before he struck her banker in Union Bank of India, such and such. So, my Lord, the petitioner is who? Pradeep Kumar Das, who is the authorized representative. My Lord, I don't dispute an authorized representative cannot move an application. But whether an authorized representative of a proprietorship firm can file the case, the petitioner should have been the wife. Affidavit can be done by the authorized. There is no dispute. I cannot dispute that fact. The notice which has been sent is sent on whose behalf? It has been sent on behalf of Pradeep Kumar Das. Who is the person holder of the check? Holder of the check is wife. Now, your Lordship.
Yes, I understood. Yes.
One more, your Lordship, may kindly see. The check has been issued at page 18.
18, huh?
Yes.
Yes.
It is issued Mega Fuels.
That's a proprietorship concern of the wife.
So,
Wife of
my submission would have been the Mega Fuels represented by its proprietor such and such, two authorized representative. And moreover, when the first affidavit is filed, the evidence in chief, it should have been by the proprietor himself, because person who is the holder of the check is to come to your Lordship's jurisdiction. Here the case has been filed by the husband and he says that my wife is the owner. Can he file a maintenance?
Yes, madam. Yes.
Your Lordship, the question that has come up in the CRLMC has been directly answered by the Honorable Supreme Court in Nourish Properties.
Yes, I'm also relying upon that.
In Nourish Properties, Your Lordship, both the appellants and the respondents, both were sole proprietorship firm, Your Lordship. And if Your Lordship, I may take to page 14, Your Lordship.
14.
Yes, Your Lordship.
Para?
Your Lordship, just now.
Yes, page 14.
Your Lordship, page 6 of the judgment, para 28.
Page 6, sir. Yes.
Page 14. Page 14 in this one.
28, yeah? Yes, since the High Court has.
Yes, Your Lordship. Here also, Your Lordship, what had happened is both the appellant and the respondent were sole proprietors, Your Lordship. The appellant had sent a legal notice. The son of the appellant, he had sent a legal notice and he had initiated a proceeding. But there was a pointer that he was the authorized representative also, Your Lordship. So here the contention of my learned senior that I have filed this complaint petition and initiated the proceedings in capacity of husband of the sole proprietor, that does not stand correct. Because, Your Lordship, my learned senior read out para 2, but in para 1 of the complaint petition, been clearly mentioned that I, as the authorized representative, I am filing this complaint petition, Your Lordship. So this question.
Show me that authorization.
Your Lordship, that is there. That has already been exhibited as.
Where is that?
5/1, Your Lordship. That is of our interim application we have annexed, Your Lordship.
Yes. Yes.
Last page of the interim application that we have filed, IA number 2649 of 2024.
2649.
Yes, Your Lordship.
Yes. Yes.
There is an authorization.
No, where is that authorization?
That is dated 12/8/2016.
Okay, 1 minute. Where is that? Don't find it. Authorization, yes.
I undersigned so and so. Do hereby nominate, authorize, and appoint Sri Pradeep Kumar Das, aged about so and so, who is my spouse and husband, to act as my true lawful authorized person of my firm, MS Mega Fuels, Your Lordship. What I intend here is, Your Lordship, when there is a liability, suppose a liability accrues against a proprietorship firm, that will only be against the proprietor, Your Lordship. But however, when it comes to filing a complaint or initiating a proceedings under 138 NI Act, Your Lordship.
Who has exhibited this? Through whom it is exhibited, exhibit 5?
We have presented it before the learned court, Your Lordship. The petitioner has approached this court after the evidence on affidavit had been taken.
Show me the cross-examination of the complaint. Where have you put this question? Show me that.
Before that,
you allow this authorization to go on record and exhibit without questioning.
Your Lordship, I have one more submission.
Show me your cross-examination. Where have you questioned that?
When cross-examination was going on, when I approached page 17, madam. Cross-examination been deferred and I have come up.
The case has been stayed in the middle of the cross-examination, Your Lordship.
Page 17, Your Lordship. Yes.
17?
Yes.
17.
I have filed my further examination in chief. It was marked. Then when the cross-examination started, I came up before Your Lordship because I have challenged that the very proceeding is not maintainable.
And
affidavit of complainant.
Yes. Signature I have objected. Thereafter it was exhibited. Before cross-examination, I have come up before Your Lordship. Cross-examination is not started from my side.
Where in the examination chiefs, where have you exhibited it?
Yes, exhibited. Page 17.
1/7.
I have filed original authorization letter dated 19/8/2016, issued by Sujata Rao, proprietor of Mediating. This is the said letter now marked exhibit P/5. This is my signature. They are now marked as P5/1. This is the signature of Sujata Sahu marked exhibit P. This was evidence in chief. Before examination, I have come up. Before examination, I have come up.
Before-
What my learned friend is saying, that if I were not raised that point in the cross-examination, then my lord matter would have been different because it will not go without uncorroborated.
Yes.
But I have come up at the threshold. And your lordship will see that authorization letter. Kindly, your lordship may kindly see.
Yes.
My sister read first portion. I am reading the second portion. To the day-to-day activities of
No,
affairs of
NI Act also is written.
Pardon?
NI Act also it is written.
Yes, but
Second
can
one.
he file? Well, he can be, yes.
To
he-
file Wakalatnama, to
yes,
file
he can.
and civil.
This is unregistered power of attorney. There is no dispute that unregistered power of attorney holder cannot file a case. Because only in case of.
No, your objection is how can you file an affidavit
Yes.
by way of examination in chief? That's what your case is. I understand.
But can you present the petition before the court?
Yes, Your Lordship, that can be done. I'll answer Your Lordship. Yes, Your Lordship.
Yes, so read
Your
it.
Lordship, in para 25,
25, huh? Yes.
para,
You find the judgment possible there is entirely based on the guideline rate of
This is page
18
nine.
RMs. How is the High Court of Orissa?
नहीं, यहाँ का 25,
Say-
यहाँ का 25. Para 22 of the judgment that Your Lordship is holding. Page 9, Your Lordship.
There is no specific pleading in that case. Yes.
Yes, Your Lordship.
Ah.
And here, all throughout, there has been specific pleading, Your
Yes.
Lordship. And one more thing, Your Lordship.
Which para, let us complete.
Yes, Your
it.
Lordship.
Yes.
All that is necessary is to demonstrate before the learned magistrate that the complaint filed is in the name of the payee, and if the person who is prosecuting the complaint is different from the payee, the authorization therefore and the contents of the complaint are within his knowledge. What I intend to say is, Your Lordship, in this case, the present petitioner could have challenged the cognizance order itself if he was of the view that I do not have any authorization. He waited till I present my authorization certificate, and in middle of the examination, he has come before this honorable court without attaching the authorization.
Yes. Yes.
And Your Lordship, that is why in this particular case also, the learned Supreme Court has categorically held that 142, while taking cognizance, the magistrate only has to see that the complainant has personal knowledge of the transaction that has gone between them. And in this case, nowhere has the complainant said that I am filing this case only because I am husband. Your Lordship, there may be a defect as to megafuels ta age likha itanta nole represented by so and so da pore likha itanta as we file. But in this case, what has happened is 50,000 only. The check amount is only 50,000.
Pay it and finish it.
And also, when it comes to your Lordship, I may
You are
be.
spending more money in litigation. And
No, Your
more time.
Lordship.
I thought
More
we removed
time,
my amount.
Your Lordship, more time, yes.
That impression your lordship should not carry, because I am not that, because your lordship may see who is there on the other side.
I am
He is
there.
associate
And my
She is associate of Mr.
Certainly there is good unnecessary.
Your
I thought
Lordship, another question also.
See, I have to write a judgment on this. If I accept
Your Lordship, even if disputing the question of authorization also in Darish properties,
mediation.
Your Lordship, much obliged. Your Lordship, the same.
I will not, keeping in mind the amount involved, I am not going to write a judgment in this. Don't, I will not insult both of you.
But I will never
Send it to mediation, local mediation. No.
Much obliged, Your Lordship.
My lord, your lordship may kindly see. Here.
See, point is against you also, against her also.
Yes.
I have to balance it now. Then I have to distinguish the judgment and so many things I have to do. Unless there are 50,000 rupees, why are you wasting time? Lot of people are waiting. Hey,
If Megha should have filed, in fact, I have no case.
See, it has.
Find out anybody.
The authorization letter has gone on record. You go on. Why have you come now? You are not challenging. You go and put that question and create a doubt, then you come.
Your Lordship, one more thing.
Okay, Cognizance has been very proceeding itself. My sister should read my
Yes.
petition.
List it after 3 weeks, send it to mediation. Which mediation?
Baleshwar.
Baleshwar mediation.
Again.
Yes, Baleshwar.
Then we issue notice to the party
Yes.
because my lord, both of us are here,
Yes, yes.
so we cannot.
Same, huh? Coordinator will issue notice and settle it. Yes.
The interim order may be.
Entry mode to continue till then. Yes. Yeah, 50,000 rupees. Why unnecessary? Yes.
Much obliged, Your Lordship.
May it please your lordship. Item number 65, my lord. Initially, your lordship, a FIR registered in the year 2022.
Yes.
Thereafter, my lord, the IO moved an application for remand. Service already happening, your lordship. What happened in this matter? Last opportunity granted to the learned counsel for the state.
We have
Yes.
sent the letter to obtain the instruction from the on 20 January 2025. And
you got the information?
Not yet received the.
My lord, your lordship may kindly have a glance to the last order. 7 days already.
I
taken,
know
your lordship.
he has not got the instruction. You wait for some
My lord,
time.
last order, your lordship may kindly see. By way of last opportunity, the learned counsel for the state is granted one more opportunity to seek instruction. Satna date golani again. Default bail application. This is only, my lord.
What he says is the
Whether
last
they
order.
submitted
By way of last and final
or not.
opportunity, Mr. Mahanti, learned counsel is granted one more opportunity
Yes,
to
sir.
seek instruction regarding the status of the case.
We have already sent the.
And last time also I told, why are you changing the prosecutor every time? Mr.
Every
Mahanti
day, your
is
lordship.
here now. And you are coming.
We received the supplementary charge sheet. We have already received.
I have already annexed the supplementary charge sheet.
No,
What
final.
date of-
See, 1, 2, 3, 4, 5, 6, 7 dates.
Every day they are taking time, your lordship.
What will I write? What will be my now the sentence? Last and final opportunity has gone.
Yes.
Then what should I write?
Should personally take responsibility.
So let it come day after tomorrow. I will take it.
Day after tomorrow. I'm sure we'll put it day after tomorrow. Okay.
Grateful, your lordship.
Get instruction. These kind of
Yes,
small matters. Yes.
66. Make clear. The petitioner, if your lordship is the lawyer of his bar minor, and the only alleged offence is 431 and 186 for 341.
Notice was issued.
Yes, my lord. Your lordship
Anybody
also.
is appealing? Let's take it up. Service complete. Okay. Notice was not issued to opposite party. There is no
State
opposite
has to
party.
only verify,
Only
my lord.
state. Okay.
State, my lord.
Yes.
My lord,
Yes.
the state has to only verify the material on record. It doesn't implicate the petitioner with regard to any kind of material. Only ମୁଁ ଜାଣିବାକୁ ପାଇଲି ଯେ ଏଇ ଲୋକମାନେ ଠିଆ ହେଇକିନା ରାସ୍ତା ଅବରୋଧ କରୁଥିଲେ. That is the allegation. And there is no material on record to show that any kind of restraint to the public to the my lord, to discharge the duty.
There are 8 accused.
Yes,
You have come.
petitioner-
One of them have.
Yes, only
Yes,
the
yes.
lawyer.
Surya Das Gupta.
Lordship already.
Rana alias Surya Das Gupta.
Aye.
Surya Das
Rana
Gupta.
alias.
Accused number 3.
Yes, yes.
Accused number 3.
ଏଇ ମେଟେରିଆଲ ଖାଲି ଅଛି ସେ ରାସ୍ତାରେ ସେମାନେ ଅବରୋଧ କରୁଥିଲେ ପାଣି ରାସ୍ତା ଯୋଉ ନାଳ ପାଣି ଗଣ୍ଡଗୋଳ ହେଇଥିଲା ସିଏମସି କୁ ଡକେଇଥିଲେ ସିଏମସି ନ ଆସିବାରୁ ରାସ୍ତା ଅବରୋଧ କରିଥିଲେ that is the only allegation.
Mr. Vishal, just check it out.
Yes, yes.
Okay.
ଆପଣ
Vishal,
କିଛି
check
ନାହିଁ
it
ମେଟେରିଆଲ।
out. For the instruction. Yes. Yes. Simply.
67.
This is that case where I had filed a date chart wherein I had shown that in view of your lordship judgment, where your lordship in the case of CRLMC 1003 of 2021, wherein your lordship has been pleased to quash the proceedings on the ground of 106 of Factory Act, where there is a limitation on the taking of cognizance beyond an statutory period of 90 days. Now, my lord, your lordship may see the last order sheet had filed a date
Give
chart.
me the date chart.
My lord, I have already, that's already there on the record. On the last date, I had.
In the court, if you give something,
I'm sorry.
generally throw it.
It is-
Then they are
I have a copy
paperless.
now.
Yes, so. Incident, Form 20,
My lord,
Form 18 just.
I am conscious of your lordship judgment. I have also held it from the date of filing of Form 18. I have not taken it from the date of knowledge, as is there in the.
The date incident happened on 18/1/2020.
My lord.
Date of you have information Form 18 is 24/1.
My lord.
From 24/1, if you recon,
My lord.
then the complaint was filed on 61 days.
My lord. No, that is 61 days delay.
Or 1 day delay.
No, my lord, 61, the first case is 61 days delay. Your lordship has seen. That is a calculation just on.
So 151 days.
My lord.
So 61 days.
So my lord, as if you.
This is the first case.
Again.
That is CRLMP 2815.
My lord.
And the second one is 21 days.
My lord. Only the last case, if your lordship remembers, it was 1 day, and your lordship had asked the state council that
Yes.
maybe there is a.
On 12th February, we discussed with the complainant, and he said, gave assurance to give detail of information within 2 days. Recently, we have discussed.
So insofar as 2815, 2153,
Yes.
and these two,
Yes.
where there is a delay of 61 days and 21 days, I am allowing those petitions. And the first two petitions I will allow. The rest two, because these delays are very, very less, 1 day and 3 days, let him seek instruction. Okay. Jyoti, the petition de do first data de do, first data allow karo, first second data adjourn karo. Okay. And give the papers to me. Huh? And give dictation. Yes. Yes.
68.
May I please your lordship? The petitioner before your lordship is an senior officer of the Bharat Petroleum Corporation, Hindustan Petroleum Corporation, stationed at Mumbai.
Yes.
But the Hindustan Petroleum Corporation floated a tender
May I please, lordship?
Kindly grant some time for filing of the objection. This is the case of 354A
Lordships,
and 509.
lordships, I could lay my hands on a paper, my lord. This was the Department of Paper, though I had not filed it through an affidavit, my lord. Lordship may kindly peruse. Lordship. Internal committee was formed, my lord, with 6 senior officials. They heard both the parties at length, my lord, and the closing is at my lord, second page, my lord.
Yes.
That's in the joint sittings of respondent and complainant, my lord. That is the petitioner and the OP2. Dated 11th October 2023, the following observations were made. Both
Mutual reconciliation.
Lordship.
Are you reconciling? Settling?
No, Lordship.
That's all.
But there you have said that.
No, that is they have.
There you have said that both the complainant and the respondent agreed. Give a copy.
I will give you a copy.
70.
Lordship may kindly see in this petition, the petitioner's praise for quashment of criminal proceeding on the ground that the loan amount avoided by the petitioner has already been deposited and he had squared up the loan amount, and the agency from the Orissa Khadi Grammar, the board from which the petitioner availed the loan, he has also given the no objection certificate. Lord, I am guided by 3 judgments of the Honorable Apex Court, where the Honorable Apex Court has quashed the criminal proceeding on the ground that these are mainly mercantile in nature, the transactions, or any banking in nature, and therefore the criminal trial should not be proceeded with.
B.B. Agarwal.
Lord, I have given the recent judgment, but they have Lord, they have followed the judgment of B.S. Joshi and Nikhil Merchant,
I am citing Tarina Sen, K. Bharti Devi and Central Bureau of Investigation.
BB Agrawal and Marchant will help.
Lords, I'm grateful.
Yes.
Lords, may kindly.
Who is appearing for the other side?
Lord, notice was already issued. My learned friend is appearing, but the state has filed the Lord. The affair was lodged by the Odisha Khadi and Gramodak Board, Lord. If your Lordship will see as page 15 of my CRLMC.
K. Bharti Devi you are replying.
Lordship. The first page I have earmarked the paragraphs of the judgment, relevant paragraphs of the judgment.
Yes. You are appearing for bank.
So the OP number 2 here also.
Yes.
What do you say? You simply tell whether the entire money is paid.
That has been paid after the initiation of proceeding, Your Lordship, the certificate case, and that is under OPDR Act. Thereafter, the petitioner has paid the amount.
That case is dropped.
Yes.
Yes, Your Lordship.
Certification case is
Yes.
dropped.
Yes.
But I have enclosed the copy, Lord. Look, the loan.
But how will you?
Case,
How will you get over this judgment, Bharti Devi? K. Bharti Devi.
Lordship, this so far as I have gone through the judgment, Your Lordship, that is on a settlement, Your Lordship. But here,
OTS settlement.
yes, Your Lordship. After the settlement, this judgment has been passed, Your Lordship.
And all
but
the
there is no compromise between the petitioner and the opposite party number 2, Your Lordship. After initiation of proceeding, the petitioner has deposited such amount, Your Lordship. So after the initiation of proceeding,
it's not voluntarily.
Yes,
it's not voluntary.
It is not voluntarily, and it does not absolve himself from the criminal liability. That is my submission.
But my
and while the trial,
let us see the judgment. The facts are undisputed. Facts
Lord,
are
my answer is, Lord, I have also.
No, facts are undisputed. Facts are undisputed. Let us see the judgment. How will you apply this judgment? Yes. And those cases, even Marchant and BB Agrawal says that once there is an OTS and the bank has agreed for that, and you pay
the outstanding amount, including interest. Your Lordship will appreciate that.
I quashed one proceeding there recently. Judgment I have given, relying upon these two judgments. CBI's case against the petitioner I have quashed.
Yes, Lord.
Saying that there was an OTS. In the OTS, there was a condition that no, despite the payment being made, criminal case will go on. That was the part of condition in OTS.
Here also, Lord, there is no such condition, Lord.
So therefore, even then I quashed it, saying that once the payment is made,
I'm grateful.
nothing survives.
Lord, here in fact 7 lakh rupees I have availed me, Lord, and I have paid rupees 29 lakhs, 29 lakhs 88,000.
Because the interest and all.
Interest amount is 20. So
that goes to show that you are so reluctant. Out of compulsion, you have to pay.
Out of compulsion,
no, my Lord. My Lord, admittedly, my Lord, the allegation was made. In the investigation, fully found that 13 persons had availed loan during that particular time frame, and out of which I am one of them. And filed the charge sheet against all those 13 persons. Since I was not the resident of Odisha, my Lord, at that point of time, I purchased a property in Odisha thereafter, and that property was attached under the OPDR Act. So I contested that case. Eventually, I, my Lord, dropped that. I contested and paid the entire outstanding in that OPDR proceeding, and paid the entire outstanding, my Lord, 29 lakhs, 88 lakhs odd. So thereafter, I approached the Lordship saying that once, my Lord, this money that was loan, that was allegedly being availed by me in a under a loan, my Lord, that has been paid by me. So therefore, the criminal proceeding.
What is alleged about it? You have taken it, therefore you have paid.
I have availed the loan.
The loan you have done. What is alleged loan?
They are saying
it is a loan you have
Yes,
taken.
basing upon forged document.
No, that was not the allegation. I'll place the charge sheet, my Lord, but charge sheet there is no such manipulation of record. Although 40468 votes.
Why 468?
Lord, I'm saying.
Let us come to the judgment. If the facts are then
we'll
see. Just see the judgment. This is an OTS.
Yes.
First judgment is an OTS.
In that case, also DRT proceedings were initiated. So therefore,
obviously, the bank has agreed that therefore there is an OTS and paid. But here you contested it.
No, I am not contested. My Lord, here also, OA case, in those cases also, original applications were filed against the defaulter. They contested the matter. Eventually, they expired of the loan amount. They ended with compromise.
Yes.
My Lord,
let us see the Bharti wala.
My Lord, I have my first case is Tarina Sen, my Lord. Your Lordship is reading, second.
China Sen, I've seen it. That is an OTS.
So then, K. Bharti Dev, your lordship may kindly. Parak 28, if lordship.
Here, this Bharti is also OTS. Thereafter, the settlement has taken place and disposed of in term. The OA was disposed.
OA, yes,
disposed of.
So during the pendency of OA, they come to a compromise and paid the amount. So here also, Miller, during that recovery proceeding, I paid the outstanding amount and approached your lordship to court.
See, the idea you don't understand. The idea is, suppose there is an OTS. The bank has entered into an OTS, they settle. Thereafter, the same bank can't go to the criminal court and say that he has done and all these things. Yes. Because the settlement has taken place. Therefore, Gyan Singh was used and it was quashed. But here is a case, by compulsion you have contested, thereafter you paid money. The test is whether if you are subject to the criminal prosecution, whether they can succeed for obtaining a conviction against you or not. That's the test.
That banking or mercantile.
If had it been an OTS, the bank officer would not, can't go and depose against you. So therefore, the criminal prosecution is a futile exercise. But here the case is the reverse.
But they have received the money, unless now in that case, had they not received the money or contested with the.
No, that's not the idea. You show another judgment. May I receiving the money?
They have received the money without any objection.
No, they received money on the basis of OTS, then the judgments apply.
Recovery proceeding is one kind of OTS, because I proposed to make the payment, they accepted it.
Therefore,
Miller, there are certain offences which are compoundable in nature. So
that is a different test altogether.
So therefore, these are the offences which are compoundable.
You just tell me which judgment supports you the best.
Miller, page 17, para 28.
Which judgment? Bharti, I read it. Next judgment come.
That forgery part is saying, Miller, that is lordship can say para 20. That is emphatically been observed by the Honorable Supreme Court.
28,
page 17, 28.
Yes.
This court found that though the offence punishable under section 420 IPC was compoundable under subsection 2 of section 302 320 CRPC, with the leave of the court, the offence of forgery was not included as one of the compoundable offences.
Therefore, 482 was involved.
Therefore, my lord, that is what I am saying. So your lordship has the authority to.
Have I said that I don't have authority?
So
I'm exercising. I'm hearing you that goes to that type of authority.
So therefore,
that's not the test. Just see the test. How will you apply the judgment in your facts of your case?
Para 29. Para 29.
Yes.
This court specifically noted that although it is alleged that certain documents had been created by the appellant therein to avail of credit facilities beyond the limit to which the company was entitled, the power of quashing could be exercised. This court found that in view of a compromise arrived at between the company and the bank.
That's the problem. Compromise. There is no compromise. There is a contest.
Lord, he is not contesting, my lord. Had it been a contest, my lord, they would not have received the money.
Are you not contesting?
But, my lord, once, so that is their stand. Once they have, so in that logic, my lord, if that logic is to be accepted, then once the DIT proceeding is initiated, then bank cannot compromise the matter. If that logic is to be accepted, because we have initiated a DIT case, so therefore we cannot compromise the matter.
Come to the next judgment. Duncan. Which para?
Lord, I have given my copy. First page is paragraph marked. First page, index.
First page. No, Duncan, you have not marked. Oh, first page.
First page. Right.
This is para 42.
Para.
Yes.
Para 29, I find it relevant.
Here also the same thing. It says that in the civil proceeding, the claim of both the banks have been satisfied and the dispute have been compromised.
So here the civil proceeding initiated by
compromise. They are not compromising. They have initiated a proceeding and under the pressure of that proceeding, you have to pay. You have paid.
Milord, I have.
Have they come? If you,
Milord, I have.
you should have been wiser enough to compromise with them. Since you are paying, you should have paid that.
Milord,
Instead of that, you
Milord,
contested.
Milord, I have not contested, Milord. That proceeding itself.
You may not have. Okay. I am just simply, you prepare further, huh? Because you have an interim order. I don't want to prejudice.
It's not.
Right, but see, the problem is technically he is a difficulty, but the fact remains he has paid. And with the interest and all. You prepare it. Simply urgent interim order to continue. Prepare properly. Get some, these judgments are not helping you. These judgments are not helping you. Try and find out something else. Yes. Yes. That matter is there. Yes.
May I please? Item 71, madam.
71, yes.
In this, in both the appeals, my lord, they are similar to each other. And in this appeal, my lord, the railway has challenged the impugned order dated 4/9/2019 passed by the RCT, directing the railway for refund of the freight charges demanded on the petitioner, on the respondent matter, wherein the learned RCT has not taken the section 79 and 83 of the Railway Act. So also, the
yes,
wherein and also the consignment as specified by para 3B, Roman 3 and para 3B(V) of the rate circular 36 of 2009, my lord. And this appeal has not been admitted. My humble submission before your lordship is that let the LCR be called for and admit the appeal be admitted. And we have today, my lord, the matter has been fixed before the RCT for attachment proceeding, my lord. Already they have filed the application for attachment and today for orders, and we have filed an application as this matter, both the matters have been.
No, that is clarified on 16/7/2024. It is clarified. See, it is made clear that the pendency of the present appeal shall not be a bar to execute the order.
No, that is proceeding, but it needs adjudication. And similar matter, my lord, have been pending before the Honorable Apex Court for adjudication regarding distance-based charges. And I have also, my lord, there is a list, my lord, wherein these both the writ of petitions before this Honorable Court which are pending, they are also transferred for the same issue, my lord. WPC number, my lord, 21124 of 2014 and 228182 of 2014, my lord. These are also pending before the Apex Court for its adjudication.
What are the issues?
Well, these distance-based charges.
Yes, Mr. Math. Yes, one.
Yes, ma'am.
Seemingly
Is this issue is pending?
As just said, seemingly innocuous prayer, I should not be objecting to that. One the difficulty is this. This case was decided by the Learned Railway Claims Tribunal in 2019. Before it was decided, my lord, the two judgments, the two writ petitions that my learned friend is relying on, I am one of the petitioners. I am appearing in one of the cases. Those cases are, my lord, cases where the virus of the rate circular has been challenged.
Okay.
And my lord, there is a direct order of the Honorable Supreme Court specifying that these two writ petitions shall be stayed. I have given those, man.
Okay.
So they have specific writ petition which has been stayed of my lord, Honorable Calcutta High Court and Honorable High Court of Orissa. Now, my lord, may kindly note those are of writ petitions of 2015 and 2017. Now, my lord, while this case was being heard before the learned RCT, they never raised that point that, my lord, so please don't hear these matters. These are sub judice before the Honorable Supreme Court. My lord, because of two reasons. The list or the issue at hand is not the same.
Yes.
Now, my lord, there, as my lord said, that the rate circular itself was under challenge, and hence Supreme Court said that let it be stayed. We will
hold on till we.
Now, my lord, here interestingly, what we are saying is we are not challenging rate circular. We are saying even if the rate circular is applicable, facts are completely different.
And that is what the learned RCT, my lord, held and gave us the finding that, listen, you have imposed rate circular on them, whereas they don't even come under this at all.
Yes.
So whether the virus or whether rate circular is correct or not is not the question. Now, my lord, number two, my lord, may kindly understand my predicament. I am also a Government of India undertaking, my lord. Kudrebook, my lord, KIFCL.
Yes.
Now, my lord, I have got this award back in 2019.
Hmm.
Now, my lord, my learned friend came before your lordships, filed an IA in 2019 along with this. My lord, never pursued it. Never prayed for your lordships to get a stay. Never. Let me complete. I did not intervene. Now, my lord, then, my lord, they tried, if I may use the word, my lord, they tried all these tricks saying that it is similar to Honorable Supreme Court. My lord has seen the orders.
Yes.
My lord, the coordinate bench recorded my submission and asked them categorically, show me an order of Honorable Supreme Court where this matter has been stayed. You were there before Honorable
Yes.
Supreme Court. Please get a stay.
Hmm.
Now, my lord, it has already been more than 6 years. They have not been able to obtain that order. Now, my lord, they still go ahead and say, no, it's the same case before the Supreme Court. If that be so, you had that case, my lord, was decided in 2015, 2016, still pending. You could have gone to Supreme Court and said that these writ petitions or these.
Yes. You
that
could have intervened, whatever.
Exactly, my lord. Now, my lord, when Honorable learned RCT, my lord, after 5-6 years, we have been pursuing it. My lord, at the fag end, when they're trying to execute the order, now they are coming and seemingly saying, my lord, this is pending. Please admit it. And so we can go ahead. Now, my lord, I have no problem if this is admitted. I have no problem if that is stayed.
You hold on the execution petition.
No,
That's
my lord, I have no problem if the
No.
execution proceeding is stayed. My lord, let them deposit. So, my lord, after 6 years, they deposit in this court. I have no problem. But, my lord, how can they go by completely ignoring the order, coming here? I have no problem, my lord, if it is. I go.
Do you have any order to show that the similar issue is pending?
Yes, my lord.
Yes. But Ms. Mohanty says that you have been searching like this in 6 years.
No, my lord. There is a order of stay. It is admitted. He is also.
So that's what his case
it
is.
is
Since
in
last
his
6
knowledge.
years, you have been searching like this. You are not able to produce.
No, my lord. It is there.
Will you, again, you will keep on searching, or you have anything to show me? Yes. Yes. What is this?
In this case, my lord, all
the order.
matters are.
Where is the order? Where is the order?
I have that is stage control.
All connected matters.
Stage control.
All these connected matters are to be listed, but how will they come to know that these are connected matters and issues are?
Madam, this is there, madam. Until further orders, the further proceeding in the following cases will remain stayed, madam.
How will I come to know that the issue pending before Supreme Court is relatable to this case?
This is the Honorable Apex Court has already tagged up all the matters and passed this.
What are the issues involved in all the cases? Where from I'll get it?
I have to file the SLP copy, madam. It is also.
Fix.
Madam, this is.
For petition, distance-based charges are same issue.
You are being represented by a lawyer.
Sir,
Please hold on. Yes.
And this is also I have given that.
But you just tell me, how will I relate that the issue pending before Supreme Court is same as that of the present case?
Yes, ma'am. In the other two cases, which cases I have earlier relied upon, my lord, the two writ petitions, those orders I have also, my lord, passed by this honorable court, which were transferred to the honorable Supreme Court, my lord.
Show me that.
Yes, ma'am, that order is also there.
No, keep it in the first week. Yeah, I'll keep it in the first week. Let him get all these orders. Get all these orders, not
No,
like
no,
that.
this is,
No, place it on record. Place it on record. I'll dispose it up immediately. It's not a very big matter. Small matter, you place everything on record. Yes.
my premier, as they are going to pass the order on
Yeah,
attachment.
first week. You
Sir,
should have come with full preparation. I'm asking, you are
No,
taking out one
this
paper.
is-
How will I relate all these things?
It's
It's very difficult.
I will file,
See,
madam.
these are for final hearing. You
Yes,
can't bring one paper
No, my lord.
and if I ask question, then you keep on searching,
I'll
find out
file-
one paper.
I will file my those.
This is no way.
Well, at least my lord,
Come.
till that date, I will. Be
No. Even now, I'm not satisfied. What you are trying to say. I'm not able to comprehend what you are saying. At least some kind of preparation, some written submission, something you bring.
I will
final
file a
disclosure.
written note of service.
Whenever you will bring, I'll wish. Yes.
A date be fixed
First,
till that
second-
date, my
second-
lord.
second report.
Till that date, at least.
No interim order like this. And you have taken interim order, it is modified, so many things happen.
No, we have not taken interim order.
Whatever.
We have not taken interim order, my lord.
I'm not able to comprehend what exactly you want to say.
This matter relates to distance-based charge.
Sir, you might have read it.
Well, my lord, when they have taken that, booked that rag, my lord, the consignee has to send some documents which they have not complied with, my lord. That's why it was that, this is the merit.
My lord.
That's why, my lord, that's why, my lord, I pray that the appeal be admitted and the LCR be called for.
No, at least you satisfy me. Why? You prepare
When I
properly.
submit, they are saying the on merit, that is. What I will say, madam.
Factor
The-
of similarity has to.
Madam, that is.
You please prepare and come.
Yes, madam. I will file a written note. But madam, today they have.
Today I am not satisfied. Today I am not satisfied. What you are saying?
Day after tomorrow.
No.
Madam, till that date, madam.
This matter is listed. You should have come prepared. Yes,
Next 3 days, madam.
Next item.
Get
Next
to-
item. Don't let us not waste. All hearing matters. Then
So-
I'll 75.
Can be disclosed.
Yes, give me. 75 disposed of. Yes.
No, copy has not been served on me.
75%. 75.
75 mallards, yes.
75. Yes.
I am there in item 75.
And I pray at least one adjournment petition be filed that.
No, I couldn't understand what you are trying to say so far. How will I pass an order?
The matter relates to
Prepare and come. Don't do that, please. Don't do that in the High Court level. At least you should
Fix a date, madam, short date, 2 to 3 days.
That I will do it. You
Two to-
prepare and come properly. Yes. If there would not have any opposition, I can understand. He's fully prepared and opposing. You are whatever I'm asking, taking out one page from your file, throwing on me. What this is no way of doing it. Yes. It will be there because I have a in-camera hearing, therefore I'm going. Any
Item 74, 76.
all matters will be here only. I'm not disturbing them. Any matter which is settled or something of that sort, I just yes, it will be there. Every day I'll take. Yes. Yes, two of them I have appointed him as a amicus curiae. You are prepared. I'll hear it tomorrow day after. Get ready because I have heard him already. In third appeal I have heard, and two appeals I think I have appointed you as amicus curiae. One appeal and one appeal you are appearing. You please prepare and let us finish up. It is a parted matter.
Note also. I am available.
Parted, I'll hear it tomorrow.
84 my lord, Patana matter my lord, much. Happened that case my lord, director of my lord, my senior is there my lord. Is appearing one of the appeal, I am appearing another appeal my lord. And we'll file short notes, lord speak. Patana already had this matter my lord.
I don't remember.
We are ready my lord. To pass
You prepare a short note so that I will hear just 10-15 minutes. I'll finish it up.
But the two cases, 81 also same, my lord.
Yes.
81, another
Okay.
case, my lord.
Now let us do it 84. Let us do it.
My lord.
Let us do 84. Then okay. Thank you.